Government.
Please sit. Take your seat.
Take breathe.
हाँ आराम से 5 मिनट ही जाओ. Yes. Page 27. May I get? Just a minute. Okay, start. Mostly Hadi Digal. Hadi Digal PW?
1.
Huh?
That's 4, sorry, 4.
4. अच्छा.
Yes.
In front, father of the. Mic tap adjust करी in front. Father of the deceased. Yes. लिखी अणागा एकी जे मोर झियो ममता दिगाल बयस प्राय 16 वर्ष हेबो बीसी हाई स्कूल रे 8th श्रेणी पाठ पढुथुवा कुसुमबुटा ग्रामर प्रमोद दिगाल एड्रेस सहित प्रेम संपर्क थिला एणु गत कार्तिक मासरे सेमाने ममता दिगाल इज द डिसीज्ड ओके डॉटर ऑफ द इन्फॉर्मेंट एंड वाइफ ऑफ द
and Pramod Diggal is the appellant,
Yes, my
right?
Yes.
Okay. हाँ
हाँ,
अष्टम श्रेणी पाठ पढ़ुला बेले appellant सहित तार लव
पढ़े।
अफेयर थिला हाँ तापर पढ़न
एकथा प्रमोदर बापा को कहिथिला कि आमे नहीं परस्पर
एणु
भल
गत
पाई मो
कार्तिक मासरे सेमानकर
कार्तिक मासरे सेमाने
पढ़ंतु के आमे
परस्पर
केस को बुझीवा तापरे हाँ
कार्तिक मासरे सेमाने परस्पर भल पाई मो घरु पळाइथिले एकथा प्रमोदर बापा को कहिथिली ओ आमे उभय पक्ष बाहागर पाई राजी होइथिलु सेही दिन ठारू सेमाने स्वामी स्त्री हिसाब रे रहुथिले
ठीक
मझिरे मझिरे मोर झियो ज्वाई प्रमोद दिगाल आम घर को जिबा आसिबा करुथांती गत मंगलवार 2/1/2007 संध्या समय मोर झियो ममता स्वाई प्रमोद आम घर को आसीथिले ता 3 तारीख दिन आम घरे रहिले ता 4/1/2007 तारीख रे संध्या रे से दुई जण कुसुम बाट जीवु बोली कही चली गले आज 5/1/2007 सकाळ 6 घंटा हेब प्रमोदर मा गमाली दिगाल आम घर को आसी पुओ झियो कुआडे गले बोली पचारिले मु गतकाली संध्यारे तम घर को बोली कहिली से गाँ को चली गले मोर स्त्री सायावती दिगल मोर शाली बनिता दिगल गाँ
Sayavati Diggal has not been examined.
ना not examined.
Okay.
Banita has been
examined as
Yes.
PW5.
Yes.
Okay.
गाँ चारि पाखरे खोजा खोजी कलु
ठीक
खोजिबा समय रे कुसुम बाटा रास्ता गुमापदर गोटिए आंब गछ तले रास्ता पाखरे मो झियो ममता मरी पड़िछि ता बेकले धारुआ अस्त्र द्वारा कटा चिन्ह अछि बहुत रक्त बाहरी पड़िछि ओ बेकरे पिंधिथिबा लुगार कानी बंधा होइछि प्रकाश थाउ कि मोर ज्वाई प्रमोद दिगाल गत 4/1/2007 तारीख संध्यारे मोर झियो ममता दिगल को ता घर को नेउथिबा समय रे उमापदर ठारे केनोसी धारुआ अस्त्र द्वारा बेकरे मारी हत्या करिछि प्रमोद दिगाल मते आगरु ममता को अन्य का सहित बाहा करी बा पई ठीक करिछ कि बोली पचारुथिला मु ताकू मना करिथिली से से मो से राखी मो झियो को
से रखी
से राग
गटा एटु कटि जाइछ से राग
रखी मो झियो को प्रमोद दिगाल मारिथिबार विश्वास करूअछि एणु एही रिपोर्ट होइछि आहार तदंत हो
तो आसस एफआईआर रे जहा आसुची जे लासिन अछि आई विटनेस बोधे केही नथिबे ओके आई विटनेस लासिन विषय इनफॉर्मेंट सपोर्ट कला
पुणी आईओ पाखरे किंतु डिफर करछि 161 ने
अच्छा PW4 आउ की लासिन तांग घर लोक आउ के कहिना PW4 अच्छा सो वन आइटम इज लासिन नंबर 2 what are the other circumstances
page para 19 your lordship may take
trial court rate
yes page 20 para 19 is summed up 5 circumstances
para 19
page 20 lordship
page 20
first one is the motive
wait
to sum up
second
oh ita achi ha पढ़िले से para 19 टा
to sum up the proof circumstances are one the motive second one the last seen together alive theory third one is the presence of ball stain on clothes of deceased which tallies with the blood group of deceased and also presence of the injuries on the person of the accused which probably must have been caused in the tussle of the deceased fourth one is leading to discovery of the weapon of the offense MO1 the knife and the opinion of the medical officer that the injury on the deceased must have been possible by the knife, and lastly the absconding of the accused from the village. The chain of circumstances proved by the prosecution unfailing connects the accused with the crime.
So motive part रे की कहउचंदी
PW5.
5 कौची
अच्छा मोटी वाला PW5 तो last scene वाला PW4 and then number 1 is that leading to discovery of MO1
and PW1 to not
leading to
supported.
discovery MO1
They did not support.
No.
अच्छा PW1 PW2
Two.
not supported.
Not supported.
Okay तामने बाकी IO रही थी वो
I.
IO कितने नंबर से की
PW8.
PW8 IO क्या उड़ा कौन कहला blood stain so and so must have been caused as a tussle.
C report.
अच्छा C report रहेला
C report.
अच्छा C report कितने
Exhibit 16.
Exhibit 16 is 64
At 65.
64 बाकी रहेला blood group of the deceased and also presence of the injury and the person of accused को की examine करची
15 नेला C report 15.
हाँ 15 16 में
ना 15.
अच्छा accused or injury doctor
PW9.
PW9 यति तो circumstance हो
In one circumstance, he has missed, your lordship.
अच्छा absconding विषय की कौन IO छोड़ा IO only okay so that is PW8 IO हाँ आउट कौन कहले
The blood patches that were found on the body, on the wearing apparels of the accused, have been found identical to that of the deceased.
same group
Same group.
अच्छा
That has not
that
been
is the
stated,
C report अच्छा
lordship.
blood group on wearing apparel of the appellant
Appellant.
अच्छा tallies with the blood group of the deceased right अच्छा okay the defense please total denial or what
Denial.
से last scene को भी denial करची
हाँ मिछ सब होई गई
अच्छा last question टारे कौन आंसर देजी
मिछ केस करछन
मिछ केस करे अच्छा okay so let us start with last scene then
yes
PW4 you said the witness to that
yes. Page 42.
PW4 obviously is the informant in the
Yes,
case
madam.
okay he is the also the father of the deceased right
Yes madam.
please place it
Momata Diggle is my daughter. She died 1 year back. She was reading in class 8 in Visipada school. I know the accused. My daughter used to complain that the accused used to harass her on her way to and from her school. I had asked the accused not to harass her. In November 2006, the accused took my daughter to his house. I tried to bring her back. My daughter refused to come back. She stayed in accused's wife as his wife. What?
Accused house.
House.
Accused house in his wife.
As his wife.
Accused house.
On 2nd January 2007, both of them had come to our house. They stayed till 5 p.m. of 4/1/2007. Then they both left our house. Next day at about 5 a.m.
That means within 2 months this of that occurrence took place. So to jain rahila. Yes, next कौन हला? At about 5 p.m.
Next day at about 5 a.m. accused mother and aunt came to our house to inquire also where the accused and the deceased had been. I told that they left our home yesterday at 5 p.m. Then I entertained doubt. We went in search of my daughter. Inside Gumapadar forest, which is half kilometer from my house, I found dead body of my daughter lying near a mango tree. Her neck was found cut from front side. We went to accused's house. Accused's father was present. None else was present. Accused was not there. We brought accused's father to show him the dead body. I asked him to watch the dead body and went to Sadara PS to lodge a report. On Vaikuntha, one Vaikuntha Digal wrote a report as per my narration. Exhibit 4 is the report. Exhibit 415 is my signature. 4. With police, I came to spot again. The police held inquest in my presence and prepared a report. Exhibit 5 is the inquest report. Exhibit 5/1 is my signature. Then the dead body was taken for postmortem. The deceased had put on one blouse, sari and green blouse and pair of ear flower. The same were on the dead body when I first saw it and when the police conducted postmortem. Cross examination. My elder daughter is given in marriage 2 years back in village Kainjhar. Accused was reading in Talapada High School. Deceased fell in love with the accused. She left my custody of her own and want to live with the accused. For 2 months they lived together. During that period, they came to my house twice or thrice. On the day following the elopement of the deceased, we intervened and their marriage as per caste custom was solemnized. Accused father is deep. He is poor. I am also poor. I do not know if the accused was having any income. It is not a fact that myself and my wife are not interested to give the deceased to the accused family. He volunteers. The accused parents were dissatisfied with the deceased marriage with the accused as we are poor. My house is 3 kilometers from accused village. There is only one road connecting my village and accused village, which is jeepable. There is another pathway through jungle. To quote, the accused and deceased took the pathway while they left my house together. Again says I cannot say which route they took. It is not a fact that villagers go to Gumapadar jungle to attend call of nature. I did not accompany the accused and the deceased to see them off. My wife was also in the house. She also did not see them off. It is not a fact that accused left my home on 4/1/2007 at 10 a.m. and my daughter deceased was not allowed to go with him, and that my daughter stayed with us in the night 4/1/2007. In our village, there are 16 houses with 40 to 45 population.
plea तो आपण नहीं नाहंती
ସେଇଟା ନେଇଛୁ ସେଇଟା
ଏଇଟା ଆପଣ ସଜେସନ ଦେଲେ
ହଁ
ଆପଣ ଡିଫେନ୍ସ ବି ନେଇ ନାହାନ୍ତି ଯେ ମୁଁ ଦିନ 10ଟା ବେଳେ ପଳେଇ ଆଇଲି ଆଉ ମୁଁ ତା ସାଙ୍ଗରେ ଆସି ନଥିଲି ଖାଲି ମିଛ କଥା କହିଛନ୍ତି
The site where dead body was lying is not rocky, but its surface is uneven. I was not interrogated by the police. I have never narrated before others all that I have stated today. It is not a fact that I have not stated before the IO that the deceased and the accused together left our house on 4/1/2007 at 5 p.m. It is not a fact that I have stated before the IO that first the accused left my home in the evening when my...
It is not a fact that I have stated before the IO
He denied
that
first accused left.
The accused left my home
and when my daughter refused to go with him sometime after departure of the accused, my daughter left home to attend the call of nature. But a statement prove ही अपन IO through रे
IO through yes.
अच्छा देखिए को लाइन टा
Para 24 of the IO's deposition.
Page के दें
Page number 56.
Page 24.
Page 56, para 24, your lordship.
Para 23.
I had examined. Please read it that last. Para 24.
I had examined PW4. PW4 had not stated before me that the accused and the deceased left his house on 4/1/2007 together. He has stated before me that the accused had first left the house, and the deceased refused to accompany him. And sometime after departure of the accused, her daughter left her home to attend the call of nature, but she did not return.
Okay, let us see that 161. ये जो PW4 बाहर कले ट्रायल कोड रेकॉर्डटा देखिलो कौन था ना PW4 रो
Hadi digalo.
हाँ
Hadi Digal.
हाड़ी दिगल এটা কোন ভাগ করছে 161 কইলি ব্রা
161
কোন
এইটা পেজ 71 onwards 72 Hadi Digal 72
ହାଡ଼ି ଦିଗଲ ଉପରୋକ୍ତ ମୋକଦ୍ଦମାରେ ସୁଆଂଶୁ ଜମାନମୁଣ୍ଡି 7 ମାସ ତଳେ ନବମ ଶ୍ରେଣୀରେ ପଢୁଥିଲା ଝିଅ ସୁଆଂଶୁ ହୋଇ ଅଜାଣ ଗଲା ଝିଅ ବୁଝାସୁଝା କରିବା ପରେ ସେ ଘରକୁ ଫେରିବାକୁ ମନା କଲା ଏଣୁ ଆମେ ଦୁଇ କୂଳ ବିଚାର ପରାମର୍ଶ କରି ଝିଅ ମମତା ସହିତ ପୁଅ ପ୍ରମୋଦର ବାହା କରାଇବାକୁ ସେଇ ଦିନଠାରୁ ସେ ଦୁହେଁ ସୁଆଂଶୁ ସ୍ୱାମୀ ସ୍ତ୍ରୀ ହିସାବରେ ରହିଲେ ମଝିରେ ମଝିରେ ଝିଅ ଜ୍ୱାଇଁ ମୋ ଘରକୁ ମଧ୍ୟ ଆସନ୍ତି ପ୍ରମୋଦ କାମ ଦାମ ନ କରି ଖାଲି ଘରେ ବସି ରହିବାରୁ ପ୍ରମୋଦର ବାପା ବୀର ସୁଆଂଶୁ ଆମ କଥା ଅନୁଯାୟୀ ସେ ଦୁହିଁଙ୍କୁ ଅଲଗା କରିଦେଲା କିଛି ଦିନ ସେମାନେ ଦୁଃଖ କଷ୍ଟେ ଚଳିଯିବା ପରେ ଖାଇବା ପିଇବାରେ ଅଭାବ ଅନୁଭବ କଲେ ପ୍ରମୋଦ କିନ୍ତୁ କାମ ଧାମ ନ କରିବାରୁ ତାଙ୍କର ଚଳିବାରେ କଷ୍ଟ ହେଲା ଝିଅର ଦୁଃଖ ଦେଖି ମୁଁ ଓ ମୋ ସ୍ତ୍ରୀ ଦୁଃଖ କଲୁ ଏବଂ ମମତାକୁ ଅନ୍ୟ ଆଡେ ଭଲ ଘର ଦେଖି ବାହା ଦେବା ପାଇଁ ସ୍ଥିର କଲୁ ଆଚ୍ଛା ଗତ 2/1/2007 ତାରିଖ ସନ୍ଧ୍ୟାରେ ଝିଅ ମମତା ଜ୍ୱାଇଁ ପ୍ରମୋଦ ଆମ ଘରକୁ ଆସିଲେ ଆମ ଘରେ 3 ତାରିଖ ଦିନ ରହି 4 ତାରିଖ ସନ୍ଧ୍ୟାରେ ପଳାଇ ଯିବା ପାଇଁ ପ୍ରମୋଦ କହିଲା ଓ ମମତାକୁ ମଧ୍ୟ ତା ସହିତ ଯିବା ପାଇଁ ଜିଦ୍ ଧରି ବସିଲା ଏଥିରେ ମୋ ସ୍ତ୍ରୀ ଓ ମମତା ଯିବା ପାଇଁ ମନା କରି କହିଲା ତୁ କାମ ଦାମ କରୁନାହୁଁ ବେକାର ତୋ ମା ବାପା ଭଲ ନୁହନ୍ତି ଆମ ଝିଅ ତୋ ସହିତ ତମ ଘରେ ଆଉ ଚଳିପାରିବ ନାହିଁ ଏଣୁ ସେ ଆଉ ତମ ଘରକୁ ଯିବ ନାହିଁ ମୋ ସ୍ତ୍ରୀର କଥା ଶୁଣି ପ୍ରମୋଦ ମମତାକୁ ବହୁତ କରି ବୁଝାଇ ଚାଲ ପଳେଇବା ଯିବା ବୋଲି ଡାକିଲା ମମତା ମଧ୍ୟ କହିଲା
ମୋ ମା
ଯାହା କହିଲା ତାହା ହିଁ ଠିକ ମୁଁ ତମ ସହିତ ଯିବି ନାହିଁ ଏଣୁ ସେହି ସନ୍ଧ୍ୟାରେ ପ୍ରମୋଦ ରାଗି ତମତମ ହୋଇ ତାଙ୍କ ଗାଁକୁ ପଳାଇଗଲା ପ୍ରମୋଦ ଯିବାର କିଛି ସମୟ ପରେ ମମତା ତା ମାକୁ କହି ସେଇ ସୁଆଂଶୁ ଗଲା ଦେଖୁ ଦେଖୁ ରାତ୍ର ହୋଇଗଲା ମମତା ଫେରିଲା ନାହିଁ ଏଣୁ ଆମ ମନରେ ସନ୍ଦେହ ହେବାରୁ ମୁଁ ଓ ମୋର ସ୍ତ୍ରୀ ମିଶ୍ର ସୁଆଂଶୁ ଜାଗାକୁ ଯାଇ ଖୋଜିବାକୁ ଆମ୍ବ ଗଛ ଗାଁ ପଟେ ଦୁଇ ହୋଇଥିବାରୁ ସେଇ ରାତିରେ ଆମେ 2 ଜଣ ତାଙ୍କ ଘରକୁ ଝିଅ ଆସିଛି କି ବୋଲି ନାହିଁ ପଚାରିବାରୁ ଗଲୁ ଆମ କଥା ଶୁଣି ସେମାନେ କହିଲେ ଆମ ବହୁ ଘରକୁ ଫେରି ନାହାନ୍ତି ଏଣୁ ଆମେ ସେଇଠାରୁ ଗାଁକୁ ଫେରି ଆସିଲୁ ମୁଁ ଭାବିଲି ଯେ ତାର ବାପା ମା ପ୍ରମୋଦକୁ ଅଲଗା କରି ଦେଇଛନ୍ତି ବୋଧହୁଏ ସେ ସୁଆଂଶୁ ରାସ୍ତାରୁ ପାଇ ଧରି ଅନ୍ୟ କୌଣସି ବନ୍ଧୁ ଘରକୁ ପଳାଇଥିବ ଏହା ଭାବି ନ ଖୋଜି ରାତିରେ ତୁନି ରହିଲୁ 5 ତାରିଖ ଦିନ ଭୋର ସୁଆଂଶୁ ପ୍ରମୋଦର ମା ଆମ ଘରକୁ ଆସି ଝିଅ ଜ୍ୱାଇଁଙ୍କ ବିଷୟରେ ଯେଉଁ ପ୍ରକାର ପଚାରିଲା ସେଥିରୁ ମୋତେ ସନ୍ଦେହ ହେଲା ଏଣୁ ମୁଁ ମୋ ସ୍ତ୍ରୀ ସୁଆଂଶୁ ଶାଳୀ ମିଶି ଏମାନଙ୍କୁ ଖୋଜିବାକୁ ଗଲୁ ଜଙ୍ଗଲ ଭିତରେ କିଛି ବାଟ ଯିବା ପରେ ଗୁମାପଦର କୁସୁମପଟା ରାସ୍ତା ପାଖରେ ଗୋଟେ ଆମ୍ବ ଗଛ ପାଖରେ ମୋର ଝିଅ ମମତା ମରି ପଡିଥିଲା ତାର ପିନ୍ଧା କାନିଧା ସୁଆଂଶୁ ବେକ ପୁରା ଧାରୁଆ ଅସ୍ତ୍ରରେ କଟା ହେଇଥିଲା ଭୀଷଣ ରକ୍ତ ବାହାରି ଦେହ ସାରା ସୁଆଂଶୁ ହୋଇଥିଲା ଓକେ ପ୍ରମୋଦ ଆଚ୍ଛା ଏଣୁ ତାକୁ ପ୍ରମୋଦ ମାରି ଦେଇ ପଳାଇ ଯାଇଛି ମମତାର ଅନ୍ୟ ସହିତ ବିବାହ ଦେବା ପାଇଁ ମୁଁ ଠିକ କରିଥିବା ଜାଣି ରାଗରେ ପ୍ରମୋଦ ଏହି ଘଟଣା ଘଟିଥିବ ସୋ this statement about the last scene is telling for the first time in court.
He has stated in the FIR also, Your Lordship.
FIR re achi, but the statement which has been given by the police is something different.
Yes.
You are right that FIR
At the first instance ଅଛି
FIR ରେ କଣ କହିଲା 4 ତାରିଖ ଦିନ ସନ୍ଧ୍ୟାରେ ସେ ଦୁହେଁ କୁସୁମପଟା ଯିବ ବୋଲି କହି ଚାଲିଗଲେ। ଆଜି 5/1 ଆଚ୍ଛା ହବ ସନ୍ଧ୍ୟାରେ। If FIR is there,
Yes.
which is not there in 161. 161 ଅଲଗା ଅଲଗା ସମୟରେ ଯାଇଛନ୍ତି ବୋଲି। ଆଚ୍ଛା, any members of the family of PW
ବନିତା
4
Bonita,
Bonita acha,
PW5.
PW5, let us come to that.
Last parara he has spoken that.
No, you
Please
have to
start,
read.
start.
Please.
Yes.
Read. Now, Idi Bonita Idi, how he is related to the deceased?
Yes.
Mausi.
Mausi, acha. Aunt of the deceased. Okay. Hold on.
Deceased is my niece. Accused is deceased husband. About a year back, I happened to meet deceased parents in village Pipali. When they told me that they were going in search of the deceased and the accused, they further told that accused parents have come to their house in search of the accused and his wife, as they were reportedly missing. I accompanied them. While we are searching for the deceased and her husband, we found the dead body of the deceased lying inside a forest. We found her throat cut. There were no other external injuries. I am a co-villager of the accused, but our house situated in different sites, situated half kilometer apart. On 3 occasions, I have come across the accused parents reporting the accused also why he fell in love with the deceased and brought her as his wife, whose parents were very poor and not able to give dowry. They used to tell the accused to drive away the deceased and
rebuting kar deech. Yes.
they used to tell the accused to drive away the deceased and marry another lady who would bring sufficient dowry. They used to pick up quarrel with the accused and deceased wife. I had last seen the accused and the deceased in accused house a few days before detection of dead body. Cross-examination. Often I go out of my village on work for wages. My house is 2 kilometers away from the deceased parents. It is not a fact that deceased parents were not happy with the marriage between the accused and the deceased. Since they were poor, they were happy that their daughter could marry the accused. It is not a fact that deceased parents had arranged one youth to give the deceased in marriage with him, and the deceased was not willing to marry that youth. Deceased was in deep love with the accused, for which she would not have agreed to marry someone else. What I have narrated today was not narrated before any other person. I was interrogated by the police, but not the cause of death and circumstances leading to the death. It is a fact that I have stated before the IO that when accused called the deceased to come with him, deceased's mother did not allow her to go with the accused, telling that the deceased would be given in marriage with someone else, and that on such refusal the accused left her village. It is not a fact that I, being the Mausi of the deceased, was falsehood. It is not a fact that my allegation against accused parents are all false.
That means he has perhaps stated about that the appellant left first and then okay, that he has not stated during trial, which has been brought out by the defense. Let us see again the 161 of that lady, Bonita Deagle. ନାଇଁ ସେଇଟା ନୁହେଁ, ଏଇଟା କଣ ବିନ ଡିଗଲ ସତ୍ୟବାଦୀ। ହଁ ଏଇଟା page 76 ना एठी बाहर कर दियो सन करे
No, but just
अच्छा रो
74.
6
हाँ
हाँ so आज दिन सुआंशु बयान है कि जे मु मुतकी ममतार माउसी अटे अच्छा ममता 6 मास तले सुआंशु पढ़ुथिला बेले असुर भल पाइला काम नाम न पढ़ते जो ता बापा मा अलगा कर देले प्रमोद और ममता बहुत असुविधा हला मु सुनिया को पाइली गत सुआंशु रे बुलिया को आसीतले ओ से आसीथिबा खबर पाई 4/1/2007 दिन सेमानकु देखिबा पाई खरा बेले मु आसी पहुंचिली देखा साक्षात पर संध्यारे प्रमोद ममता को नहीं तांको गाँ को जीवा को बाहरिला जीवा पाई कहिबारु मो भौणी मायावती डिगल प्रमोद को कहला आमे तुमको आम झील आउ देबु नाही अन्यत्र विवाह देबु तमे जाई पार ना हाँ जाई पार प्रमोद ममता को जीवा पाई डाकियारु ममता मध्य जीवा पाई मना कला ममतार प्रेम ता प्रति कमी जाइथोरु से रागरे तम तम होई से संध्यारे प्रमोद अच्छा प्रमोद गाँ को पलाई गला प्रमोद जीवार के समय परे ममता डिगल सुआंशु गला से आउ राति पर्यंत फेरिला नहीं आमे सब व्यस्त होई ताकू चारिआडे खोजिलु काले घर को जाइथिबो परा भाबी मोर नानी और बेणे सुआंशु को खोजिबा को गले सेठारे पहुंची जानिया पाइले प्रमोद ममता तांको घर को आसी नहांती काले अन्य कहा घर को जाइथिबे भाबी घर को फेरी आसिले 6/1/2007 सकाळ 5टा समय 6टा समय प्रमोदर माँ नानी घर को आसी प्रमोद ममता पाइल कि बोली पचारे ता कथार आमको सन्देह लगे से चली जावा पर आम 3 जन ममता को खोजिया को लगिलु सुआंशुरे रास्ता कड़े आंब गछ पाखे ममता मरी पड़ता देखिलु ममतार पिंधा लुगा सुआंशु थिला प्रचुर मोर नानी प्रमोद सांगे ममता को न छाड़ ममता को अन्यत्र विवाह देवाई कह प्रमोद सहित
सही न
पारि अच्छा ममता को कौन शुण सो এই পার্টটা যদিও 161 এ থিলা is also stated about the same thing like that witness informant जे ये आगुरु गला से गलानी कहला ये कौन गोटे आ गोटे जगह बाहागर तार बोधे ठीक करथिले ये भी से झील भी राजी हलानी तेणु से आगे गले ये so that is his suppressing in the during examination in chief but they have brought it out in the cross examination. Okay, so any other witness so far as the last scene is concerned? Okay, now we are going to prove that motive is that se jo ଆଉ ଗୋଟେ जो ବାହାଘର ଠିକ କଲେ
ନାଇଁ ପୁଅର ଡାଉରୀ ଆଣିନି ସେଥିପାଇଁ ଇଏ ଖାଲି ମୋଟିଭ ଏଇ କହିଛି PW5
ନାଇଁ ତ ସେଇଟା ତ ମୋଟିଭ ନୁହେଁ ଇଏ ତ ଦି ଜଣ ଯାକ ପୁଅର ଥିଲେ ନା
ସେଇଟା କହିଲେ ଏଇଠି ଖାଲି କହିଛି ଏଇ ଯୋଉ
ଡାଉରୀ କଥା କୋଉଠି କିଏ କହିଲା
ପାରା 3 ରେ ଖାଲି କହିଛି
नो नो रादर दी मोटिव इज दैट ସେମାନେ ତାକୁ ଆଉ ଗୋଟେ ଜାଗାରେ ବାହା କରେଇଦେବା ପାଇଁ ହଁ that is the
ଆଉ ଗୋଟେ ଡାଉରୀ ମିଳିବ ପୁଅକୁ ବାହାଘର କରିଦେବେ
କୋଉଠି କହିଲେ କୋଉଠି ଛୋଟ
ପାରା 3 ରେ
ହଁ ନାଇଁ ସେଟା ତ ରିବ୍ୟୁକିଂ କରିକି ଯେତେବେଳେ ଝିଅ ସେଇଠି ଥିଲା ତାକୁ କହୁଥିଲେ
ନାଇଁ ଏଇଟା ଇଏ କହୁଛି ତାଙ୍କ ଘରେ କଜିଆ ହଉଥିଲା ଏଇଥିରେ ଆଉ ଗୋଟେ ଝିଅକୁ ବାହାର କରିଲେ ସେ ଡାଉରୀ ଆଣିବ
ସେଟା ଗୋଟିଏ କିନ୍ତୁ ମେନ୍ ହେଲା ଏଇ ଯୋଉ ଘରକୁ ଯୋଉ ଫେରିଥିଲା ରାଗ ତମ ଯୋଉ ହେଲା ମୋଟିଭ ଷ୍ଟାର୍ଟସ୍ ଫ୍ରମ ଦେୟାର that somehow a statement has come from the parents that she will be given in marriage somewhere else.
Examination chief रे आसीनी सेटा
examination chief रे सेटा FIR नहीं
FIR भी नहीं
161
ने रही
अच्छा then this is so far as motive is concerned then number 3 is leading to discovery of MO1 MO1 ला से knife टा
yes
सेटा PW1 और 2 आपण कहले सपोर्ट कलेनी तो बाकी रहिला 8 अच्छा आसिले ताले आईओ एविडेंस को पळे आसन para 8 and whether that knife was containing any bloodstain
No, that has come that negative, your lordship. Knife for bloodstain nine, but the medical
knife जाइतला पठाइतला तो
yes, yes.
अच्छा
So what is incriminating then? Only recovery.
The recovery and the doctor, PM doctor has opined that that
That
knife
could
that is
can be used
possible by
possible.
So recovery is
recovery ला अच्छा PW8 रो सही पार्ट को पढ़े आसन से जो
para 8
on the same day I searched for the accused at his house and village, and I could not find. I also searched for the accused on 7-1, getting information about the concealment of the accused near the jungle.
Nearby jungle that I came to
the jungle and apprehended him in the jungle. On the same day, I arrested the accused at 11:30. 7-1-11:30 से मिला. I brought the accused to the PS. On the same day, the accused, while in my custody, in presence of witnesses, gave statement leading to the discovery of knife from inside his house. I recorded the statement of the witnesses exhibit to the relevant portion of the statement of the accused leading to the discovery. Thereafter, the accused, in presence of witnesses, led to his house and brought out the knife from the low-level body and handed over it to me. Exhibit 2/3 is my signature. Exhibit 2/2.
One ta बोधे सीजर लिस्ट है.
yes
देखिए ठीक से one ta सीजर लिस्ट exhibits from the house of the accused, place of seizure on production of this one. So
अच्छे then.
government of High Court of Orissa. अच्छा. But the doctor ये जो bloodstain could not be detected in A to C. इटा कितने नंबर मार्क इतला exhibit जो
D ta
D knife टा इतला D हाँ ना wooden handle ना knife हाँ D right. So that is in page 62. It is D, and the D was found to have contain no blood stain. That is. Okay, so blood stain on N1. बाकी हाँ आ गोटे कौन आपण कहले जे ब्लड ग्रुप जो आ वेयरिंग अपैरल्स टू मैच कला बेली सेटा किए
सेटा ई युवा full pant full shirt जोटा सेटा वो अछि.
So what he has stated about the circumstance पचराई जी 313 रे जे तमठू जो पोशाक मिलिला से पोशाक रे ब्लड ग्रुप आसिला ओ ग्रुप जोटा कि होची डिसीज रो ब्लड ग्रुप हां पचराई जी नहीं नहीं हां ठीक ठीक 20 पर मिछ कथा 29 हो सेटा मिछ अच्छा अक्यूज्ड पूरा खंडिया खबर आइतला.
Yes.
की एग्जामिन करछु
PW9, your lordship.
let us come to that.
Page 58.
One abrasion is there in the lower lip, another abrasion is there on the nose, simple in nature, so and so. The injuries are possible during tussle. with the human being. The injuries are also possible by fingernail during tussle. Injuries are possible also. By mistake, I had mentioned so and so that in case of 7-1-2, there was transferred from country 2 days. I did not send the injury person and hand over the inquiry for this one. I was reported. But who is the doctor who conducted postmortem examination?
6. 48.
Doctor examine accused. EW9. EW6?
Yes,
EW6.
48.
48?
8.
Court mark on the front side of the neck. What's on it? Just also death. Cause of death responses of the emergency death. PM report ଟିକେ ବାହାର କଲ ଏଠୁ ଦେଖିବା exhibit ଟା mark ହେଇଛି as exhibit 5 ହଁ ଏଟା Mr. Mishra, if we let us say it is FIR is there, but two witnesses of your prosecution side, if we accept their version and about also the previous statement that there was no last scene, in fact, the husband, that means the accused, left the house, and sometimes thereafter the deceased went to attend call of nature. So এটা তো আপনাদের মানে ইনিশিয়াল কেস যেটা কি এফআইআর কেস অলগা, but that was the case. So there cannot be any that how the accused will know that this lady would come to attend the call of nature, that so that he will wait and finish her.
No, that part has not been developed by the prosecution. But the villages are very nearby.
ଆପଣଙ୍କର ୱିଟନେସ୍ ମାନେ ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟ ଦେଇଥିଲେ ଟୋଟାଲି ଡିଫରେଣ୍ଟ ଷ୍ଟେଟମେଣ୍ଟ। ଆପଣ ଏଇଟା ଲାଷ୍ଟ ସିନ୍ ଆମେ ବର୍ତ୍ତମାନ ଡିସ୍କସ୍ କରୁଛୁ। ଲାଷ୍ଟ ସିନ୍ରେ ଯଦି ସ୍ୱାମୀ ପଳେଇଲା ଆଗରୁ ରାଗ ତମଥମ ହେଇକିନି, ଦେ ଆର୍ ପ୍ରୁଭଡ୍ ଅଲସୋ ଦ୍ୟାଟ୍। ଏବଂ ଗ୍ରାଉଣ୍ଡ ହେଲା କଣ ଯେ ଇଏ ମାନେ ଛାଡିଲେନି, ତ ସେ ତ ପଳେଇଲା। ତାପରେ କିଛି ସମୟ ପରେ ଆପଣଙ୍କର କେସ୍ ହଉଛି ଡିସିଜ୍ଡ ଗଲା ଆଟେଣ୍ଡ କଲେ। So the a probability of the appellant knowing that the deceased was come out of the house to attend the call of nature and accordingly will wait in that place where the people used to go to attend the call of that probability would not be there. ଯଦି ଏଇ ଆପଣ case ହୁଏ
My humble submission is that both the villages of the accused and the deceased are very closely located, Your Lordship. Distance is only 2 kilometers. The population is also very low, 40 or 50. That is the deposition, Your Lordship. So therefore, Your Lordship.
No, no. ଆପଣ ଦେଖନ୍ତୁ ଗୋଟେ usual route ଥିବ ଗୋଟେ ଲୋକଟା usually ଗୋଟେ ଆସେ ଏଇ ସମୟରେ ଜଣେ ଲୋକ ଛକିକିନି ଥିବ ତାକୁ ମାରିବା ପାଇଁ it's a different matter. But why is coming out at that point of time to attend the call of nature? So ordinarily it would not be known to the accused that whether she will come out or not and for what purpose. Obviously that cannot be ନା ତା ପ୍ରେଜେନ୍ସ ରେ ବି ତ ଆପଣଙ୍କର କେସ୍ ହିଁ ହଉଛି ଅଲଗା ଯେ ନାଇଁ ଦି ଜଣ ଯାକ ସାଙ୍ଗ ହେଇକିନି ଗଲେ and distance of the house of the accused and this the deceased their paternal place এটা বোধহয় 3 কিলোমিটার না কোন
2 kilometers.
2 kilometers.
Village Kusumbata is 2 kilometers.
The trial court has believed the last seen theory, firstly because it has been stated in the FIR, and secondly the trial court has formed an opinion that after stating that the PW4 has seen both of them together in the FIR, that statement while made to the IO should have confronted that statement to the witness, Your Lordship.
No. If FIR in view of this settled position that it is not the encyclopedia and it is not the substantive piece of evidence. ଆପଣଙ୍କର FIR ପରେ police ଯଦି record କରିଛି statement ଏବଂ ଦିଟା witness consistently କହିଛନ୍ତି ଏବଂ now they are giving a go by to that statement obviously to bring that last scene again which has been proved by the defense that no their statement is completely different before IO in their 161 statement. ତେଣୁ ଏଇ type ର ଯଦି contradictory statement ଆସିଲା we are that how far the court can place reliance on that whether the court would leave everything and just rely on that FIR theory that FIR ରେ ଯାହା ଲେଖା ହେଇଛି when the law is that it is not the substantive piece of evidence purpose is only for this purpose ତାହେଲେ ଆପଣ ଯୋଉ କହୁଛନ୍ତି ନା court rely କଲା FIR ରେ ଲେଖା ହେଇଛି ବୋଲି when the witnesses have stated differently then what is the purpose of recording the 161 statement and how what is the purpose of then 145 of the evidence and how the case the court is to assess the evidence ଆପଣଙ୍କର witness ମାନଙ୍କର statement ଯଦି completely contradictory ହବ ଏଇ last scene aspect ଆଉ କିଛି ମୁଁ ଯାଉନି we are not going to last scene ରେ ଆପଣଙ୍କର are you not can you ଦିଟା statement କୁ ଆପଣ ରଖିଲେ can it be reconciled ଗୋଟେ statement ରେ ଆପଣ କହୁଛନ୍ତି ଆପଣଙ୍କର ସାକ୍ଷୀ କହୁଛନ୍ତି ଏମାନେ ଛାଡ଼ିଲେ ନାହିଁ ଇଏ ବାହାଘର ତାଙ୍କର ଇଏ କଲେ ଝିଅ ବି ଗଲାନି ରାଜି ହେଲାନି ଇଏ ରାଗ ତମତମ ହେଇକିନି ପଳେଇଲା ତାପରେ ଗଲା ଏଇ statement ଦିଟା ସାକ୍ଷୀ ଆପଣଙ୍କର we are competent witness present also ବର୍ତ୍ତମାନ ଗୋଟେ ସାକ୍ଷୀ କହିଲା ଯେ ଇଏ ଆଉ ଗୋଟେ ସାକ୍ଷୀ ଟୋଟାଲ ମନା କରିଦେଲା ମୁଁ ନଥିଲି ମାନେ ସେଇ ଖାଲି PW ଯୋଉ ମାଉସୀ ଯିଏ ମାଉସୀ is something different totally different ତେଣୁ ଏଇ ପରିସ୍ଥିତିରେ whether it can be said that those two witnesses version are consistent so far as this one of the circumstances ଅନ୍ୟ କଥା ଛାଡ଼ି ଦିଅନ୍ତୁ and whether the London trial court has merely because it is mentioned in the FIR and stated by of course PW the 4 in court even though his statement is different was proper
so one of your submissions might be to some extent material, at what point of time then the FIR is to be corroborated? So the FIR corroborates the statement made by the witness on oath.
Yes. But
even though it is different than
in the
161
161 statement.
but it corroborates the FIR. And in the same parlance, we are also not able to read 161 except for contradiction. Here, FIR corroborates, 161
This is
contradicts.
this PW4.
Lordship.
Please come once again. Let us go through it. କାରଣ ଯଦି ଆପଣଙ୍କର ଲାଷ୍ଟ ସିନ୍ ଫେଲ୍ କରି ଯାଉଛି, ବାକି ଯୋଉ ଷ୍ଟେଟମେଣ୍ଟଟା ରହିଲା ଗୋଟେ ଛୁରୀରେ ସେଟା ହେଇପାରିବ, ଛୁରୀ ତ ରକ୍ତ ମିଳିଲାନି, ଆଉ ଆକ୍ୟୁଜର ସେ ଛୁରୀ ପାଇବା ବା ତାର ପୋଷାକରେ ରକ୍ତ ହବା, ଏତିକି ସର୍କମଷ୍ଟାନ୍ସ ଯଦି ରହିବ, how far
and the injury on the body of the
injury and
Yes.
injury is also there, that is not explained.
So please come to that PW4 once again. You come to that paragraph number 2. Please come, that page 42.
On 2/1/2007, both of them had come to our house. They stayed till 5 p.m. on of 4/1/2007. Then they both left our house. Next day at about 5 a.m., accused mother and aunt came to our house to inquire also where the accused and the deceased had been. I told that they left our home yesterday at 5 p.m. Then I entertained doubt.
No, next day means it is 5th January.
Yes, madam.
5th January, 5টা মানে ভোর 5টা
Early morning.
early morning আসি পৌঁছেছি।
Then I entertained doubt. We went in search of my daughter. Inside Gumapadar forest, which is half kilometer from my house, I found dead body of my daughter lying near a mango tree. Her neck was found cut from front side. We went to accused house. Accused father was present. None else was present. Accused was not there. We brought accused father to show him the dead body. I asked him to watch the dead body and went to Sadar PS to lodge a report. One Boykuntha Digal wrote a report as per my narration. Exhibit 4 is the report. Exhibit 4(1) is my signature. With the police, I came to the spot again. The police held inquest in my presence and prepared a report. Exhibit 5 is the inquest report. Exhibit 5(1) is my signature. Then the dead body was taken for postmortem. The deceased had put on one blue sari and green blouse and pair of ear flower. The same were on the dead body when I first saw it and when the police conducted postmortem. Cross examination. My elder daughter is given in marriage 2 years back in village Kainjhar. Accused was reading in Talapada High School. Deceased fell in love with the accused. She left my custody of her own and want to live with the accused. For 2 months they lived together. During that period, they came to my house twice or thrice. On the day following the elopement of the deceased, we intervened and their marriage as per custom was solemnized. Accused father is dead. He is poor. I am also poor. I do not know if the accused was having any income. It is not a fact that myself and my wife were not interested to give the deceased to the accused family. He volunteers. The accused parents were dissatisfied with the deceased marriage with the accused, as we are poor. My house is 3 kilometers from accused village. There is only one road connecting my village and accused village, which is jeepable. There is another pathway through jungle. To court, The accused and deceased took the pathway while they left my house together. Again says I cannot say which route they took. It is not a fact that villagers go to Gumapadar jungle to attend call of nature. I did not accompany the accused and the deceased to see them off. My wife was also in the house. She also did not see them off.
This wife has not been examined.
No.
Okay.
It is not a fact that accused left my home 4/1/2007 at 10 a.m. and my daughter, deceased, was not allowed to go with him, and that my daughter stayed with us in the night 4/1/2007. In our village, there are 16 houses with 40 to 45 population. The site where the dead body was lying is not rocky, but its surface is uneven. I was not interrogated by police. I have never narrated before others all that I have stated today. It is not a fact that I have not stated before the IO. The deceased and the accused together left our house on 4/1/2007 at 5 p.m. It is not a fact that I have stated before the IO. The accused left my home in the evening when my daughter refused to go with him, and sometime after departure of the accused, my daughter left home to attend call of nature, but she did not return in that night. It is not a fact that I stated before the IO that 4/1/2007, when the accused asked my daughter to go with him back to his home, my wife and my daughter did not agree, despite of repeated persuasion by the accused. It is not a fact that since my daughter met untimely death and we were not happy with the accused financial position, we have alleged falsely that the accused and the deceased left my house together, even though the accused left home at 10 a.m. On 4/1/7, I had filed 1cc case in the court of SDGM Fulwani against the accused, his mother, and his aunt. Further crossing. It is not a fact that I have stated in my complaint petition that 4/1/2007 at 5 p.m. the accused and his mother and his aunt along with the deceased left my house together.
Complaint petition na FIR?
complaint
ସେଇଟା
ସେ mean କରୁଛି
ସେଇଗୁଡା mean କରୁଛି. So ଏଥିରେ କୋଉଠି କହିଲା ଯେ ଏମାନେ
it's not, that is correct, suggestion and answer is correct. So the
ଏତ ନାଇଁ ଏମାନେ ଦି ଜଣ ଯାକ ଗଲେ ବୋଲି କହିଲେ ପରା 3 ତାରିଖ ଦିନ ଆମ ଘରେ 4 ତାରିଖ ଦିନ ସନ୍ଧ୍ୟାରେ ସେ 2 ଜଣ ଲେଖା ହେଇଛି ଗଲେ ଆଉ ସେ କଥା କୋଉଠି ଆସିଲା ଯେ ତା ବାପା ତା ମା ନା କଣ?
This suggestion is not accepted. So the first statement that has come from the mouth of PW4 at the very first instance directly in FIR, again directly in the evidence, will have more weightage than the one that has not been recorded in his own handwriting. 161 is the recorded by the I.
Why you have did not take, you simply suggested why you did not take that plea, whether it was not required on your part to say that ଯେତେବେଳେ ଏଇ ପ୍ରଶ୍ନଟା ପଚରା ହେଲା ଯୋଉ ସାଙ୍ଗ ହେଇକିନି ଆପଣ ଗଲେ ଖାଲି ମିଛ କଥା କହିବା
ଡିଫେନ୍ସ କାଉନସିଲ ଥିଲା ସେ ମିଛ କହିବୁ ସେଇଟା କହିଛନ୍ତି ବୋଧେ ମିଛ କହିବୁ ସବୁ ମିଛ କରିଦେଇଛି ଗୋଟେ
ସେଟା ତ ଇଏରେ ଯିବନି କିନ୍ତୁ a plea positive evidence could have been there. I was not, but because this is also no, he could not have taken, because subsequently his conduct is also that he was not in the village.
Yes, he was absconding.
He was absconded.
And he was apprehended near that jungle only.
So he was roaming around that side only. Sure. On getting information, the police went to jungle and arrested him there.
After 3 days, Your Lordship. On 7/1, he has been active.
That is how the parents of
3
the
days he
deceased,
was absent.
the parents of the accused were also searching for him.
Yes, Your Lordship.
So the last scene part, now the only witness is PW4 because PW5 has not stated about that.
The trial court has believed that PW5 was not there.
PW5 was taken from our house.
Yes.
During search.
During search, yes. That is what the trial court has believed.
Which was a different in that 161.
Yes,
it was different.
So 161 seems to be different in both the cases, PW4 as well as PW5.
PW5, right.
So that is giving a different story. We don't know why it has happened like that.
PW5 had gone through.
Otherwise, this is consistent. Had it not been consistent story of the PW4 that has come at the very first instance in the FIR and coherently in the statement on oath, and has also denied the suggestion of the defense that there was they did not move together. He has denied. So
dead body ta kebe detect hela ta paradino?
Yes, next day.
What is the time? They say morning bodhe.
एमाने खोजिला बेलकु देखिले during search on 5th probably.
Next day I told so yesterday 5 p.m. then I entertained doubt. We went in search of inside this one so half kilometer from I found the dead body lying so okay. So 5 तारिख दिन dead body मिलिला एवं 5 तारिख दिन ही इत्तला दिया है
4 p.m. The FIR has
been lodged. But if your motive is that very thing that perhaps this boy was not doing anything and the parents are interested to settle the marriage of the deceased with somebody else, then how it would be expected that they would leave the deceased in the company of the appellant?
As per the prosecution case and also as per
no, just आपण सब गुड़ा को देखियो पड़ो ना आपण मोटिव को लिंक करिवे लास्ट सीन संगरे तो रीजन होची आपणकर लास्ट सीन होची पळेले आपणकर मोटिव होची जे ये हला बेली आपण so whether both these things stand together that जदि बापा मां करो इच्छा थिला आपणर केस होची जे से डाउरी मागू कि घर को आस्थिला एवं ସେମାନେ ଅନ୍ୟ ଜାଗାରେ ସେଟଲ କରିଦେଲେ ଏଇଟା ହଉଛି ସେଇଥିପାଇଁ ଆର ରାଗ ହେଇଗଲା ଏଇଆ ଯଦି ଆପଣଙ୍କର କେସ୍ ହଉଛି ତାହେଲେ whether it is expected that in such a situation they would allow the deceased to go with the again comes to that last scene.
On a reasonable perspective it does not, but
no, it could be other way. Having heard this thing from the mouth of the parents that such a move is there, while moving together, he has taken a vow that she'll be finished.
Yes, that also could have been.
If you take this way, the other way is also there. Having heard this thing from the mouth of the parents that there is likelihood that the girl will be given in marriage to somewhere else, some other, and they moved her, he has decided to finish. Because he has come to know that she will be given in marriage with someone else.
The motive as per the 161 statement is different, and the motive as per
That is
the
completely
deposition
different.
is completely
That is
different.
different. On which the witness has no control.
Yes.
The witness has control over the FIR. The witness has control over his statement, which is coherent.
No, it was a love marriage.
Yes.
They stayed together for 2 months. During that period, they also visited the house of the.
Yes.
There is no complaint from any side that she was torturing anything like that, for any kind of mental torture, physical torture. Then comes on that particular day when they both of them had come.
And stayed for 2 days.
Stayed for 2 days. So during that period, the perhaps it is your case that he got some impression that they are planning to marriage. So it may, as pointed out, that it may two things, that either the parents would not leave the deceased in the company of the accused to go with them. The other thing, that the accused would leave and then finish it. So yeah. So two possibilities are there, that they might not have left, which is your also the case in the 161 statement, and the uh, other thing is that the
in that case, we may have to take the weight of evidence more in respect of the statement that supports the law more, like FIR, and the statement that gives a inkling that the probability of having the information that the girl will be given in marriage could be one of the circumstances of that triggered the deceased to see for all times to come. He finishes, and they went together, and this is the thing. In that case, one thing again comes. One thing comes, where was the knife? So there is a knife always, because knife is the weapon of offense.
Yes. Was recovered from the house of the accused.
House of the accused.
Nobody has stated that he had brought the knife with him. And so, when they left the house, they took the knife with them.
So in that way, if you see, if you believe the other story, what is there in 161, that he left first, and the proximity of the house of the accused and the deceased being so close, 3 kilometers in a village is nothing. He went and again came prepared to see, as my lord was also pointing out, to wait to see if he comes out. Is there any such thing that in his mind, that someone else is in her mind?
अच्छा ଆଉ ଗୋଟେ ଚିନ୍ତା କରନ୍ତୁ, ବାପା ମାଙ୍କର ପ୍ରୋଟେଷ୍ଟ ଥିଲା, ଧର ଆମେ ଯେ ତାକୁ ଆଉ ଗୋଟେ ଜାଗାରେ ବାହା କରିଦବା, ଏଟା କିଛି କରୁନି, ବେକାର ପିଲାଟା, ସେମାନେ ଯଦି ବି ଅବଜେକ୍ସନ କଲେ, ଝିଅ ରାଜି ହେଇକିନି ଯାଉଛି, ଝିଅ ଯଦି ରାଜି ହେଇକିନି ଯାଉଛି ଲଭ୍ ଆଫେୟାର, ତାହେଲେ what is the complaint of the accused against the deceased? ମୋ ସ୍ତ୍ରୀ ମୋ ସାଙ୍ଗରେ ଅଛି, ମୁଁ ତାକୁ ମର୍ଡର କଣ ପାଇଁ କରିବି? ମୋ ବାପା ମା ରାଜି ହଉଛନ୍ତି ସିଏ ତାଙ୍କୁ ଅନ୍ୟ ଜାଗାରେ ବାହାଘର କରିବାକୁ, ସ୍ତ୍ରୀ କିନ୍ତୁ ମୋ ପାଖରେ ଅଛି, ମୁଁ ଲଭ୍ କରିଥିଲି, ମୋ ପାଖରେ 2 ମାସ ହେଲାଣି ଅଛି, ଆମେ ସ୍ମୁଥଲି ମ୍ୟାରିଟାଲ ଲାଇଫ୍ ଲିଡ୍ କରୁଛୁ, maybe that there is financial condition, but my wife is coming in spite of the protest of the parents, is accompanying me to my house. So in that way, where is the motive on the part of the accused? Just think over it. We are just trying to give sense. See कौन ପାଇଁ बापा माँ ठीक अच्छी, बापा माँ against ହେଇଗଲେ, but ମୁଁ ଯାହାକୁ ଲାଇଫ ପାର୍ଟନର, सी तो मो संगे आसुची ना जहाँ मुल्लाप करी बाई सी तो मो संगे आसुची तार तो किसी हम सी तो आसुची माने कौन ही रेडी माने मो संगे voluntarily accompany करी so I have no grievance against my wife so why there would be motive to kill the my wife.
The one more aspect of motive is PW 4 and 5 have stated that the parents of the accused were not happy with that marriage, Your Lordship.
ସେମିତି ତ ଆସିଛି ଦି ଜଣ ଯାକ ଗରିବ ଥିଲେ
Yes, that
ଦି ଜଣ
clearly
ଯାକ ଆପଣଙ୍କର ଫାଇନାନ୍ସିଆଲ କଣ୍ଡିସନ ଦି ଜଣ ଯାକର ପୁଅର ଥିଲା ଜଣେ କିଛି ଏଭିଡେନ୍ସ ମଧ୍ୟ ଆସିଛି ଆକ୍ୟୁଜ କିଛି କରୁ ବି ନଥିଲା ଲେଟ୍ ଅସ୍ ସେ ବଟ୍ ରିଲେସନସିପ ଟା ଇନ୍ ସ୍ପାଇଟ୍ ଅଫ ଦ୍ୟାଟ୍ ଫାଇନାନ୍ସିଆଲ ଡିଫିକଲ୍ଟି ଯିବା ଆସିବା ଲାଗିଥିଲା ଅର୍ଥାତ तार किसी मुवमेंट को रेस्ट्रिक्ट करनथला कि कौनसी दाबी भी करिथिला कि अन्य कौनसी बाड़िया पिटा टॉर्चर ए 2 मास धरिकिनी ए एविडेंस नाही रादर सेमानकर आपण जो एविडेंस आनछन 2 तारिख दिन दी जन जाको वॉलंटरीली आसीथिले 2 तारिख दिन रहिले 2 तारिख रु 4 तारिख भितरे रहिबा भितरे तांको भितरे स्वामी स्त्री को भितरे किसी पाटितुंड हेतिबा कथा मध्य तो नाही देन आसुची लीव ये कथा we are opening up just think of it not that we have finalized सेइतपई बारंबार कहा जाए जे जेते आपण एसेस करिवे जिंसटा को सेते क्लियर पिक्चर आसियो we have to visualize the situation so आउ either way रे जदी possibility रहिबो माने सेठी कहा फेवर रे व्यू जीवो यदि एटा भी पॉसिबल एटा भी मध्य पॉसिबल हेई पारे that is another thing so
but that you all must always take it in the perspective of the three circumstances likely to go in the favor of the prosecution, that some adverse incriminating materials are there.
absconding is one
Absconding is one.
other is that knife of course there is no blood stain
but
third is the
matching of blood,
that matching of blood in the that blood stain that wearing apparel
and the injury which could be probable keeping in view the keeping in view the area where the injuries are there.
And bangles was also broken. Found at the
So no, bangle was broken.
No,
where?
somebody has committed or murdered. It's not that he has. It's a so somebody has committed murder, and weapon of offense is also any sharp cutting weapon. May not be that but any sharp cutting weapon. Place of occurrence is that place because the dead body was lying there, and so
who could be the third one? Because the defense plea is not that. No such positive evidence has been given here. So these aspects are there. Keeping those things in view, now it is to be seen whether the chance of the deceased being taken with the accused is more, or he would have left alone and had prepared, or that's a completely new story.
स्पॉट विजिट नोट टा जोटी डेड बॉडी मिली थला सेट तो इनक्वेस्ट हेतिबो ना
इनक्वेस्ट भी एक्यूज ना नाही हां इनक्वेस्ट रे
कोन हला नै नै एक्यूज सेटा एक्यूज इंस्टेंस तो डेड बॉडी मिलली ना तेनो एक्यूज तो सेठी नै रहइबो सेटा से माने खोजी कि नि पाइले परा जाइतले जम
सेमा त निजे पेरेंट्स
फेर हे जाइतला एक्यूज नेम टा मे बी
no that you are not correct जो accused जदी leading to discovery हला then matter is different गोटे छुरीटा ता instance रे होची तनु सेठी that's a different but एठी तो बहुत आगुरु कारण डेड बॉडी डिटेक्ट हला आपनकर 5 तारिख दिन accused arrest हेची 7 तारिख दिन so 2 days gap is there आउ बाकी हाँ स्पॉट मैप टा कौन केते नंबर एग्जिबिट ହେଇଛି ना ହେଇନି
Spot map is not there.
spot
Spot
map
map
ହେଇନି
is there, sir.
It's not there in the paper book.
Oh, it's
No, no.
not, but here it is.
Exhibit 10.
exhibit 10
10 ହେଇଛି।
हाँ spot map ଟା
So it has happened just in between.
बैंगल्स ଟା ଗୋଟେ ଆର ପଟେ ପଡିଛି ରାସ୍ତାର ଦେଖଉଛି broken bangles found so and so dead body ସେଠି ପଡିଛି
Dead body.
another thing just think over
Yes.
ଦେଖନ୍ତୁ ଯଦି deceased ଆ ସାଙ୍ଗରେ ଯାଇ ନଥିବ ହେଲା ସେ ଏକୁଟିଆ ଯାଇଥିବ to attend the call of nature and she did not return then the search would have started in that evening itself the search started when the next day when they came
Came
and
and searched, asked for the whereabouts.
that is another factor to show that no perhaps when they lived together
Yes, correct.
or that is the reason why they were rest assured
Right.
that she
She
had
has
gone
left.
to the house
Mm.
that is another circumstance so just think over it
And Lordship, the body has also been recovered from the spot map. It seems very near the path which leads to the village of the accused.
no body
Yes, that is there.
body is there is no problem in that
So say path re hi gala bale.
ପାତ୍ର ସିଏ ଯାହା ଦେଖେଇଛି ଗୋଟେ ସାଇଡ୍ ରେ ବ୍ୟାଙ୍ଗଲ ପଡିଛି ଦେଖିଲେ ନା ସ୍ପଟ ମ୍ୟାପ
Yes, yes, we.
ଗୋଟେ ସାଇଡ୍ ରେ ବ୍ୟାଙ୍ଗଲ ପଡିଛି ଗୋଟେ ସାଇଡ୍ ରେ ଇଏ ପଡିଛି of course it was the duty of the prosecution ଖାଲି ସେତିକି ହେଲେ ହବନି କାରଣ ବ୍ୟାଙ୍ଗଲ୍ସ ଟା ସେଠି ପଡିବାର ଯାହାର ନାହିଁ ତାର ବି ପଡିବାର ଚାନ୍ସ ଅଛି
Yes.
ଏଟା ଆକ୍ଚୁଆଲି ବ୍ୟାଙ୍ଗଲ୍ସ ଟା ଆଣିକିନି ଦେଖେଇବାର ଥିଲା ତାଙ୍କର ଗୋଟେ ଫ୍ୟାମିଲି ମେମ୍ବର୍ସ କୁ ତା ବାପା
Yes.
କୁ ଯେ ଝିଅର
Whether
ଏଇଟା
it
ଝିଅ
is-
ହଁ ସେଟା କରିବାର ଥିଲା ଏବଂ ଝିଅର ବ୍ୟାଙ୍ଗଲ୍ସ କୁ ଆଉ ଯଦି କିଛି ଭଲ ବ୍ୟାଙ୍ଗଲ୍ସ ଥିଲା ତାକୁ ସିଜ୍ କରିକିନି ପେୟାରିଂ କରାଯାଇ ପାରିଥାନ୍ତା
many
very
aspects
these
are
are
there.
these are the duty of the prosecution ତେଣୁ
PW4 has stated, but he has not stated about the bangles.
Mm.
About the sari and
no
earphone.
bangles only stated by that IO
Yes.
Mm.
that is seized but these are the bangles of that
How can you say that?
deceased that can the best person to say are the family members
Yes.
କେମିକାଲ ଏକ୍ସାମିନେସନ ପାଇଁ ବି ଯାଇନି ବ୍ୟାଙ୍ଗଲ
ନାଇଁ ନାଇଁ ସେଟା ଯାଇନି ବଟ୍
ପଠେଇ ନାହାନ୍ତି
ସେ ଯୋଉ ଆପଣଙ୍କର ବ୍ୟାଙ୍ଗଲ୍ସ ର ରେଲେଭାନ୍ସି ହଉଛି ଟସଲ ପାଇଁ
ଟସଲ ପାଇଁ
ହେଲା ଟସଲ ପାଇଁ ବ୍ୟାଙ୍ଗଲ୍ସ ର ରେଲେଭାନ୍ସି ଆସୁଛି ବଟ୍ ଅଗେନ୍ ଇଟ୍ ଇଜ ଟୁ ବି ପ୍ରୁଭଡ୍ ଟୁ ବି ଦ୍ୟାଟ୍ ଅଫ୍ ଦି ଡିସିଜ୍ଡ ଏଠି except the IO statement that some bangles were seized it cannot be said that those bangles
Yes.
are of the deceased
Suppose a portion of the bangle is in this side and the other portion is in her hand or
right
So that could be photograph, all these things are there.
କାରଣ କିମ୍ବା ଗୋଟେ ମନେକର ବ୍ୟାଙ୍ଗେଲ ଭଲ ଅଛି
Yes.
usually
With
ସେମାନେ
similar color.
pairing
So pairing is very important.
pairing is
That is another circumstance. Could have been more better though, but investigations are not being taken so minutely. Each of these aspects are very important.
ଆଉ ଟିକେ ଦେଖିବେ ନା ରିଜଲ୍ଟ କରିଦବା କାଲିକି ରଖିବା
The aspect that my lord has again pointed out, that the search started only after the members of accused family came and asked for the whereabouts of both.
ଆପଣ ଗୋଟେ ଜଷ୍ଟ ଗୋଟେ ନର୍ମାଲ ଇଏ ହୁଅନ୍ତୁ ଆପଣଙ୍କର ଯିଏ ଯାଇଥିବ ମୋ ଝିଅ ଯିବ ଇଏ କରିବାକୁ ଫେରିବନି ମୁଁ ଅପେକ୍ଷା କରିବି ନା ଆରାମରେ ଘରେ ଶୋଇବି ଇଜ ଇଟ୍ ପସିବୁଲ ସୋ ସାଙ୍ଗେ ସାଙ୍ଗେ ଯିବି ଖୋଜିବାକୁ କୁଆଡେ ଗଲା ଇଏ କଲା ତ ଦ୍ୟାଟ ଇଜ ଦି ନ୍ୟାଚୁରାଲ ଇଏ ଚୁପଚାପ କେମିତି ବାପା ମା ଘର ଲୋକ କେମିତି ରହିବେ ଗାଁ ଲୋକଙ୍କୁ ନେଇ ଝିଅ ଯାଇଥିଲା କାହିଁ ଫେରିଲାନି କୁଆଡେ ଗଲା ସେଠି ଯଦି ନାହିଁ ମାନେ ଯୋଉ ଜାଗାରେ ଅର୍ଡିନାରିଲି ଯୋଉ ଜାଗାରେ ମାନେ ଗାଁ ଲୋକ ଯାଆନ୍ତି ଆଟେଣ୍ଡ କରିବାକୁ ଭଲ ସେଠିକି ଯିବେ ସେଠି ନ ପାଇଲେ ଆରେ କୁଆଡେ ଆଉ କୁଆଡେ ଗଲା ତାଙ୍କ କାଳେ ଆଉ କୁଆଡେ ତ ଦିସ୍ they cannot sleep comfortably. The search started on the next day when they got the intimation. So that itself shows that one of the
that was not in the 161 FR. That was not said in the 161.
କୋଉଟା
ଯେ ତା accused mother ଆଉ aunt ଆସିଥିଲେ ବୋଲି.
No, FIR speaks na. That is why I am saying the weight of evidence should be more on the FIR, which appears to be the first instance, and that, coupled with the circumstance.
That was the question, that how the family members of the accused know that they are returning in court. 1 to 30.
ଆପଣଙ୍କୁ ପୁରା ଏଇଆ କହିଲି ଯେ 161 ଟାକୁ ରଖନ୍ତୁ ଗୋଟେ ସାଇଡ୍ ରେ ଏଫଆଇଆର କୁ ଗୋଟେ ରଖନ୍ତୁ ଆପଣଙ୍କର 161 ଷ୍ଟେଟମେଣ୍ଟ ଯଦି ଏଇଆ ଯେ accused ଆଗେ ପଳେଇଲା ତାପରେ ଝିଅ ଗଲା attend to call of nature ଯଦି ଏଇଆ ହେଇଥାଏ ଫେରିଲାନି ତାହେଲେ ସର୍ଚ ଟା ସେଇ ଦିନ ସନ୍ଧ୍ୟା ବେଳେ ହେଇଥାନ୍ତା ନା ତା ପରଦିନ ହେଇଥାନ୍ତା ଜଷ୍ଟ ଭିଜୁଆଲାଇଜ ତାହେଲେ କୋଉଟା ଉପରେ ମାନେ ଇମ୍ପୋର୍ଟାନ୍ସ ଦେବେ
କହିଛନ୍ତି ବୋଧେ ଖୋଜିଲେ 161 ରେ ଖୋଜିଲୁ ଝିଅ ନ ଆସିବାରେ ଖୋଜିଲୁ 161 ରେ
କଣ କହିଛନ୍ତି
ଯେ ଖୋଜିଲୁ ସନ୍ଧ୍ୟାରେ ଯେତେବେଳେ ଫେରିଲାନି
No, let us see that once again. Let us see that.
If I reading that 161, I have not.
Set to 161 that is why the proximate cause could be what? Whether that story in 161 could be more befitting than the one that has been stated and one FIR. That is why the question arises whether the statement in 161 is correct, befitting to the circumstance. Could it be possible?
ଆପଣ ଏଇ ଯୋଉ statement ହାଡି ଡିଗଲ ତ informant. ସେ ପାର୍ଟଟା ଅଛି ବଟ୍ ଝାଡା ଯାଇଥିବା ଯାକୁ ଖୋଜିବାକୁ ଗଲୁ ଆଉ ଗାଁ ପାଖ ସୁଆଣ୍ଡସୁ ଏକୁ
true story.
No, that is how the story developed in 161 being so different than the one that has been deposed to and the that has come in the first instance.
Two different
one that
and the
ଦୁଇ ଜଣକ ତାଙ୍କ ଘରକୁ ଝିଅ ଆସିଯିବି ବୋଲି ସେଠି ରାତିରେ ପଚାରିବାକୁ ଗଲା ମୁଁ ସୁଆଣ୍ଡସୁ
and there only you have to have seen whether the witness has a control over which on 161 or in FIR and the statement made in the court.
IOG କେତେ PW 8 ନା ଆପଣ ସେ ବିଷୟରେ ବି ପଚାରି
No, that
ନାହାନ୍ତି
has not been confirmed.
ଏଇ ଯୋଉ ପାର୍ଟ ଟା କହୁଛନ୍ତି ଇଟ ସୁଡ୍ ହାଭ୍ ଯେ ତମେ ଯାଇକିନି ଖୋଜିଲ ତମ ଝିଅ ନ ଆସିଲାରୁ ସେ ବିଷୟରେ ଖାଲି ଆଟେଣ୍ଡ ଦି କଲ୍ ଅଫ୍ ନେଚର ସି ଡିଡ୍ ନଟ୍ ରିଟର୍ନ ତେଣୁ ବର୍ତ୍ତମାନ ଆମେ 161 ର ସେଇ ପାର୍ଟ ଟା ଆପଣ ଯଦି ୱିଟନେସ୍ କୁ ପଚାରିନାହାନ୍ତି ଯେ ବାବୁ ତମେ କହିଥିଲ ପୋଲିସ ପାଖରେ ଯେ ତମେ ଯେହେତୁ ଝିଅ ଫେରିଲାନି ଆଟେଣ୍ଡ କରିବାକୁ କଲ୍ ଅଫ୍ ନେଚର ଯାଇଥିଲା ଫେରିଲାନି ତାପରେ ତମେ ତାକୁ ଗଲ ଖୋଜିବାକୁ ସେଇ ସନ୍ଧ୍ୟା ବେଳେ ତାପରେ ସେଠି ଦି ଜଣଙ୍କ ଘରକୁ ମଧ୍ୟ ଝିଅ ଆସିছে କି ନାଇଁ ପଚାରିଲ ସେମାନେ ପଚାରିବାକୁ ଗଲୁ ତାପରେ ଏଇ ଯୋଉ ଜିନିଷ ଗୁଡାକ ଏଗୁଡା ତ ଟୋଟାଲ ନାହିଁ ଆପଣ କନଫ୍ରଣ୍ଟ କରିନାହାନ୍ତି କି ଆଇଓ ଟୁ ପ୍ରମାଣ କରିନାହାନ୍ତି ସୋ ହାଉ वी विल यूज दैट ଯେତିକି ମ୍ୟାଟେରିଆଲ ଇଏଟା ତାକୁ ପୁଣି ସେ ୱିଟନେସ ର ଆଟେନସନ ଡ୍ର କରିବାର ଅଛି ଏବଂ ତାକୁ ଇନ୍ ଆକର୍ଡାନ୍ସ ୱିଥ 145 ରେ ଆଇଓ ଆସିଲେ ପ୍ରମାଣ କରିବାର ଅଛି ଏ ପାର୍ଟଟା ଯୋଉ ସେଟା ବି ପ୍ରମାଣ ହେରେଲାନି So, what we suggest that since we opened up many things before you, we want that today itself, you just think over it another time. Tomorrow, we'll, because it's a life, that both of you may find some more clinching evidence also against the accused, or may find some. So, we are not in a hurry. We have hard discussion is there. Think over the matter, okay, and don't nod the head when the use just keep pause. Yes. Jaha mu कहली जी अन्य जो एक केस रे कोनी जोटी भी जा just keep cool, think over the matter. We may be also it is our just observation. आमे तो पढ़ी नथला आमे अपन आप ओपन अप करूछु तो आपण करी किनी took time. Yes. So you may get some when you analyze you may get so uh, so till we finally decide the matter you are at liberty to make your submission, yes, particularly when it's a life imprisonment case, so it's for both of you.
Gotcha.
All the three things have to be there. आलोचना भी हबो,
right,
पर्यालोचना भी हबो ଆଉ ସମାଲୋଚନା ବି ହବ
କାରଣ
ତିନିଟା ଯାକ ହେଲେ ଯେ ଆମେ
ଯଦି
ପାଇପାରିବା
ମାଇଣ୍ଡ ଯଦି ଆପଣ କ୍ଲୋଜ କରିଦେବେ ନା ଏଭିଡେନ୍ସ ଇଏ କଲା ବେଳେ ଆପଣ ବି ଯେତେବେଳେ ରିଡିଂ କରି ଫାଷ୍ଟ ରିଡିଂ ରେ କ୍ଲୋଜ କରିଦେଲେ ବାହାରିବନି ଆଉ କିଛି ପଏଣ୍ଟ ଖୋଜିବାକୁ ଆପଣଙ୍କୁ ଇଚ୍ଛା ହବନି ତା ଭିତରୁ ସୋ ଜଷ୍ଟ କିପ୍ ଓପନ ନାଇଁ ହେଲା ଚେଷ୍ଟା କରିଦେଲେ ଇଏ ନାଇଁ ସୋ now what my esteemed brother has pointed out, that is one of the most important thing. FIR mu deli, that is in my control. Sakhi mu deli, that is in my control. 161 lekhala by third person mean the IO se kon kyadu lekhidala tenu that is not within the if the evidence of the witness in court is acceptable and it is corroborated by the sworn, so whether merely because the statement which has been prepared by the IO which is not and is not a layman, say the mane gote tribal is not supposed to see setebele kahi koilani complaint petition file karthanda amku jaithanda IO perfectly investigation korni IO to charge sheet dela na to statement re kon gadbad karchi kon e karchi se bhi kon janibo. Any statement has been recorded under 164 CRPC na
ନା
IO to se kotha kohuni na kohuchi kichi na na
examine kotla could I witness kaku examine kola non examination of any other villagers to know that whether
See, it can't be the topography of the village in that particular area or take it in the district itself.
Huh.
One house situates in a particular area and the distance of the other house is more than 100 meters amidst bushes. So hardly they come to know what happens in the neighboring house. That is the topography of that area. So entire area is full of bushes. That is how they call it a jungle.
Yes.
किंतु गोटे कथा जदि झियो झाड़ा जाइथांता एवं फेरी न थांता संध्या बेले
Yes.
कौनसी बापा माँ स्थिर ही बसी न थांते गाँ लोकों को डाकी किनी
निश्चित।
सेही संध्या बेले ही
बाहर
सब आरंभ होई थांता
निश्चित।
झियो कुआडे गला ता कौनसी जीवजंतु आउ नहीं गला कि टाणने लाग कौन हैला
All these
तार
things.
बापा माँ शांति रे सोई परिवे रात्रि रे सो दैट इज द मेन थिंग so that probabilizes the other thing that no because they lived together parents were safely that ଆମ ଝିଅ ତ ଯାଇଛି ତା ଇଏ ଘରକୁ ଆଚ୍ଛା ସେଠି ଯେତେବେଳେ ପହଞ୍ଚିଲେଣି ସେମାନେ ସକାଳୁ ଆସୁଛନ୍ତି ପଚାରିବା ପାଇଁ then they came to realize that କଣ ହେଲା ତାପରେ ସନ୍ଦେହ ହେଲା ଯେ କୁଆଡେ then all these things so just think it କିଛି ମାନେ ଇଏ କରନି just ଖାଲି କାଲି evacuate of first item and another case is also there so this will not take much time but you also this case and the other case you prepare we can take off for some time
Yes.
it may go to Tuesday also so
I need pardon, my lord. Out of this matter is imprimatur till today, my lord. That has not been listed before Justice Honorable D. Das, my lord. Let's say imprimatur till today, my lord.
what is the matter
Matter is second appeal, my lord.
hmm?
Specific date is imprimatur till today. Second appeal,
why are you mentioning the matter
because
he's for only for today I think he's but tomorrow it can be listed why are you ସେ ତାଙ୍କର ଲିଷ୍ଟ ଆମ ପାଖରେ ନବା ବୋଲି ବୋଧେ ଅର୍ଡର ହେଇଥିଲା
yes, my lord.
ଦ୍ୟାଟ୍ ୱାଜ ଦି ତମକୁ ଆସିନି କିଛି ହଁ କାହିଁ ସେଟା ଦେଖିବି it is there in the list today
No, my lord.
then
It was not been listed.
sure
But imprimatur was till today.
so it will be you filed the before the DR it will be listed tomorrow yes
Item 130, Lordship. I have filed a IA for bail that has not come. The surrender certificate not filed, Lordship. The noting is the surrender certificate is not filed. Surrender certificate.
item number 130
130.
right is Anima Kumari Dey, running counsel appearing for the appellant, files the surrender certificate, which is taken on record. She further submits that she has filed an interim application for bail.
2765 of
2765
65 of 23.
65 of 23 for bail. Registry shall place the same on record and matter be listed next week. Yes. Madam. आइए नंबर टा केते कहबे here
181 listed in the fresh admission that is
just a minute
vigilance appeal 3.5 वर्ष conviction and
181
आज्ञा
admission रे तो अच्छी लिस्ट
नहीं सेटा fresh admission appeal admit ହେଇନି
admission ହେଇନି जमा
ना एटा matter was my lord sentence was passed without hearing me. Your lordship directed me to surrender. I have surrendered and on my mention it has come up.
So where is the surrender certificate?
My lord, I am filing with affidavit.
What is the Vigilance Council?
I have informed my learned senior.
Take instruction whether he is surrender.
I am filing certified copy.
File को दिन पर
करे मना कले परा
certified
section से आपण को ये ମୁଁ ଆପଣ ସେଠି ନେଲେନି
certified copy of the surrender certificate is filed. So ସେ କଣ order ହେଇଥିଲା
खाते 11/2023 your lordship may kindly have a glance.
ସରେଣ୍ଡର କରିବାକୁ କୁହାଯାଇଥିଲା
Judgment ହେଲାଣି 17/5 ରୁ.
ହଁ ସେ ମୁଁ ତମକୁ କହିଥିଲି ପରା ମୁଁ ନ କହିଲା
Yes,
ମାନେ
my lord. According to your lordship direction,
yeah
yesterday only I think.
ହଁ ଏଷ୍ଟେଟ ସରେଣ୍ଡର
7 when the matter was listed on so and so since the appellant has not surrendered before so and so it was directed that the appeal will be taken up only after the surrender. So that is why it was not even admitted.
No, my lord.
ଆଜ୍ଞା
So now he has surrendered and so the person that let us see.
Whether the copy of the impugned judgment annexed with the appeal memo,
Yes, yes, sir.
whether that you will do.
Yes, which by the convicted so and so, second so and so, the should be so and so, convict is remanded to write. The learned counsel for the appellant files an affidavit with the surrender certificate, which is taken on record. It has never been admitted.
No, my lord.
All right.
The connected appeal, my lord, 586/23. Your lordship has admitted on 21/6/2023.
So
The
what is
co-appellant has
sentence?
been released on bail.
Sentence kete?
3.5 वर्ष
3.5 वर्ष.
Hard admit call for the trial court record. He was on bail allowed.
586 ରେ LCR was called for.
Stay realization of fine. The learned counsel, Mr. Das, standing counsel for the vigilance department submits that co-accused, namely, कौन था ना कौन हो?
ତା ନାଁ ହେଉଛି କରୁଣାକର ପଣ୍ଡା. It is in the list, my lord. It is in the cause list mentioned in the
ସାଙ୍ଗରେ ରେଫରେନ୍ସ ପାଇଁ ଆସିଛି
586/23. କରୁଣାକର ପଣ୍ଡା.
Karunakar Panda has preferred criminal appeal number 586 of 2023, which has already been admitted.
Admitted,
And-
bail granted, fine stayed. 21/6/2023.
Bail has been granted. Henceforth, the matter shall be listed with CRL number 586 of 2023. Urgent certified copy, free copy of the order be handed over to the learned standing counsel. The names, ये file करिए appearance.
No, your lordship was not going to admit this because of filing without surrendering. So I have not filed appearance memo whether
File
it
now.
is maintainable or not.
The surrender certificate, the learned counsel submit that he will file the appearance
By
memo
the end of December.
By end of December. Name of Mr. Das be reflected in the cause list henceforth. Yes.
180, my lord. Whenever listed, my lord, it may be listed along with 5.
Right.
All right.
180, my lord, 180, my lord.
Just a minute. Now 180 कौन है?
My lord, is conviction and now in custody near about 6 months.
It's a vigilance matter.
No, my lord. It is offense on 354 and POSCO 10 of POSCO Act, my lord. 5 years conviction.
It has not been admitted.
Admitted, my lord. LCR call for and all other co-accused are already bail.
Yes,
The lordship has granted bail, my lord.
So when it was admitted?
Admitted.
It has come for admission.
My lord, it is admitted. Your lordship.
No, it has no. देखिलो order number 2 पर्यंत तो admit हेई नथिला 5923 पर्यंत तापर आउ किछि order हेछि कि item number 180. And by the way, what is the conviction and what is the sentence import?
Conviction 5 years, my lord. The offense under 341, 342, and 34, and 354A, 2 and section 10 of Posco Act, my lord.
So you are now in custody.
Yes, my lord. Now you are custody, my lord.
During trial, you are on bail.
Yes, my lord. During trial.
देखो 2 number पर आउ किसी order ହେଇଛି
Also granted.
admit ହେଇଛି ନା ନାହିଁ?
Another co-accused in bail, my lord. Your lordship also granted.
In this case, 10 years conviction landed. Out of 10 years, and he presently is a 9 year 10 month in custody. I know.
We'll see when the matter reaches his problem.
I have
Pardon your
On behalf of my learned senior Mr. S.S. Rao, my lords, one criminal division matter with the opposite party's vigilance, my lords. We have come against the rejection petition under section 239, my lords. On the last occasion, your lordship had heard the matter in length from my learned senior, my lords. Your lordship had asked us to produce the order sheet if the framing of charge has been completed or not. It was not completed. We had produced the
What
order
is the
sheet
item number?
after it's outside the list, my lords.
So why are you not filing the memo? It was.
My lords, I have it, my lords. The lordship's permission.
So,
Grateful.
Maybe.
no, it's all right, but I cannot say take out of turn. I'm going serially when the matter reaches.
Item 123. I have filed an application for an interim bail matter due to mother's illness.
Instruction has been taken.
Yes, my lord.
Filed आनेगिन देखो तो कौन है?
Item 148 also, my lord. Interim bail for the will.
देखो तो आनेगिन यदि आस्ती हुआ instruction.
Pardon,
I may be pardon your lordship, someone BC.
Item 20 limitation is there.
Wait when the matter reaches, you make a mention. Yes.
Last week I had mentioned, your lordship had said the Vigilance Council be asked to come down. Item 33 of the weekly list, your lordships. Last week I had mentioned the appellant is going to retire from service next year, your lordships. May I pray any other day? It's a trap case. And he was directed by the BDO to receive the amount, but that has been oversight.
What is the item number?
33, your lordships. Weekly list.
Weekly list.
Again.
Why you hearing pain?
Again.
Today we are not able
not
to.
Today, your lordships. Not today. Any day of your lordships on your lordships board may permit.
Mention next week. We'll see that.
Okay. Lordships. May I pray lordship may put it to 7th kana dita 30 gote 1 ku rakhi chal 7 tarikh ku rahi jao jati padla 7 tarikh supplement
Rakhi janta yojana portion.
Oblige lordships.
All the matter.
Supplementary list, item number 2.
May I please? The real lot convicted under section 30 for part 2 and sentenced to arrive for 8 years. The operating party lordship page 57.
There are two appellants.
My husband and wife, your lordship.
Yes. Both of you were on bail during trial. Have you supplied deposition copies?
Yes.
Yes. Case based on circumstantial evidence. What are the circumstances?
That your lordship, PW4 is the informant, your lordship.
No, I'm asking you what are the circumstances?
Circumstances, your lordship, I'm going to take your lordship as per FIR allegation, your lordship.
I'm asking you what are the circumstances?
Circumstances, your lordship, all the witnesses found the deceased lying on the house of the appellant, your lordship. And PW4 stated that he was found tying in a tree, your lordship.
Your dead body was, the deceased dead body was found in your house.
Yes, sir.
So it is a homicidal death case. What sort of preparation you are making?
That is not in our house, your lordship, in our body, your lordship, in a house. Sorry, in a tree, your lordship. Initially,
May I?
Yes.
In fact, the dead body was found tied in a tree.
That
After
is in
getting-
your backyard of the house.
Yes.
Yes.
But the prosecution case that we inform the informant that you come and see that we have tied a thief in a tree. After getting the information, she came and found that her husband was tied in a tree and the saliva was coming from his mouth. Thereafter, he was untied and it was found.
It was her death was strangulation.
yes,
That
Yes. Death is due to
asphyxia on account of. Yes.
asphyxia.
and ligation mark is also there. So, page 26, the PW8 has stated the medical officer the neck above the side.
Strangulation, bro.
Cause of death was
Strangulation by
asphyxia,
ligature. Yes.
vital organ due to strangulation by
Yeah.
the ligature around the neck. And no eyewitness to the occurrence.
So apart from that, in your backyard of the house, the dead body was found tied in a tree.
Yeah.
What else is there apart?
No, except that, nothing, my lord. Because nobody is.
That is
May I see?
Chudra tree conduction. Yes.
PW6,
Only
Miller, PW6, before whom extrajudicial confession and PW5 also witness to the extrajudicial confession. by the accused.
What
I am reading that portion, Miller. Para 2, PW6. The occurrence took place 5th January 19
in the night in the house of the accused Jagannath Singh of village Bodhibua. While I was asleep in my house, the accused Jagannath went to my house, called me, and told that he had tied Vasudev Singh and he died. Therefore, I sent my wife Satyapatra and myself went to the spot, and I saw Vasudev Singh is lying dead on the veranda of the accused Jagannath Singh. And PW5 also stated so.
But in page number 50, the circumstances have been enumerated by the London Trial Court. That on 5th and 6th June night, so and so the deceased intimated his wife that he was going to the house of accused Reboti on getting her call. So and so stated about the fact that on the alleged night the deceased entered into the house of with the heard from so and so. Specifically stated illegal relationship between deceased and Reboti and regarding quarrel between the families. On the nights on being called by accused Jagannath, PW4 went to their house and found her husband to have been tied in a chudra tree by means of a plastic rope. PW4 requested accused and her husband to untie. They didn't listen. PW4 went inside the village to call the villagers. Found the time gap was very minimal. When PW4 left the spot to call Swanson and arrival, and she found her husband was lying dead. There is no explanation to how the death took place. All right, heard the learned counsel for the petitioner, learned counsel for the state. The learned counsel for the petitioner submits that both the petitioners were on bail during trial and they have never misutilized their liberty while on bail. The sentence imposed by the London Trial Court is 8 years. There is no chance of early hearing of the appeal in the near future. The balance of convenience is in his favor. It's a case based on circumstantial evidence. And the main circumstance is that the dead body of the deceased was found tied in a tree in the backyard of the house of the petitioners, and extrajudicial confession stated to have been made before PW5 and PW6. And therefore, the bail application may be favorably considered. And counsel for the state oppose the prayer for bail and place the evidence of the doctor bracketed PW8 who conducted postmortem examination, and he has stated that the cause of death was due to asphyxia, account of strangulation by ligature around the neck. Considering the submission made by the land counsel for the respective parties, nature of evidence adduced during trial, sentence imposed by the current trial court, fact that both the petitioners were on bail during trial, absence of any chance of early hearing of the appeal in the near future, I am inclined to release the petitioners on bail, stay relation of fine. Yes.
Item number Item number 9.
Judgment date is 43, running till 43. Judgment date is 43, 7 years for a commission of 307.
Okay. Who is the injured?
PW2.
PW2.
And doctor is?
7. Eyewitness is there. PW8.
No, injured ଅଛି ତ ଆଉ କଣ? କୋଉଥିରେ ମାରିଲେ weapon of offense?
Tira, ଧନୁ ତୀର.
Bow and arrow. It pierced in which part of the body?
Armpit.
Armpit.
Armpit. What the doctor has stated? PW7. Wound of size so and so present on the right side back near the angle of the scapula, right side, with arrow head struck within. अच्छा से तीरटा लागिन रही थला. Treated as an injured patient and discharged on so and so. 11 दिन रहिला 7/6 रे एडमिशन हैला 18/6 रे डिस्चार्ज ହେଇଛି. तो आर्मपिट रे कोन डॉक्टर ओपिनियन देइतला इट कैन कॉज डेथ. ଡାହାଣ ହାତ ଫୁଆରେ ହେଇଛି ଟି ତୀରଟା ଲାଗିଛି ଆଉ ଇଟ୍ କ୍ୟାନ୍ କଜ ଡେଥ୍ କଣ? The arrowhead pierced and lacerated lower lobe and middle lobe. अच्छा अच्छा ओहो କୋଉ ଜାଗାରେ ହେଇଛି ରାଇଟ୍ ସାଇଡ୍ ବ୍ୟାକ୍ ନିୟର. अच्छा ପଛପଟେ ହେଇଛି.
ପଛପଟେ.
ହଁ it's not on the okay
lower lobe and middle lobe.
ତ ପଛପଟ ପିଠିର ସାଇଡ୍ ହେଇଛି. that lungs କୁ
affect କରୁଛି.
So you are on bail during trial?
Yes. Arrested on 13/6/2018 and released on bail by 16/7/2018.
Are the learned counsel for the petition, learned counsel for the state, learned counsel for the petitioner submitted that during trial, the petitioner was in custody. After the petitioner was taken into judicial custody on 13/6/2018, after his surrender in court, he was released on bail on 16/7/2018. And then after pronouncement of the judgment on 25th July 2013, he was again taken into judicial custody. Further submits that the injured PW2 has stated about an arrow shot by the petitioner, which hit him below the left shoulder joint of Ahalya. Bracket रे PW2. And the doctor PW7 has noticed one injury and given the query answer to the query made by the investigating officer regarding possibility of the injury on PW2 by the arrow. The learned counsel submits that the petitioner has good chances of success in the case and balance of convenience is in his favor, and the petitioner has never misutilized his liberty while on bail during trial, and there is no chance of early hearing of the appeal. Therefore, the bail application may be favorably considered. Learned counsel for the state oppose the prayer for bail and place the evidence of PW2 and PW7. Considering the submission nature of evidence adduced, sentence imposed by the learned trial court period already undergone by the petitioner in judicial custody, in absence of any chance of early hearing, I am inclined to release the petitioner on bail, stay realization of fine. Yes.
Item number 10.
Reason therefore, Mr. Satpathy Menon, limitation petition there.
Defect 5D মানে
About to 1 year.
309. About to know, more than a year. So what is the
Yes.
sentence imposed? 8 years.
8 years for 307 and 6 year for 326 and both are continuing
Consecutively. So that is 13 years.
14.
14 years, na?
Yes, ma'am.
8 है 6, 14. All right. This is IA number 2283 of 2023. This is an application for condonation of delay. Stamp reporter has pointed out that there is delay of 391 days. After hearing the Land and Council for both the parties, taking into account the averments taken in the interim application, since it's a case of conviction where 14 years of substantive sentence have been imposed on the petitioner, I'm inclined to condone the delay. Accordingly, delay is condoned. IA is disposed of. Admit call for the trial court record.
Bail.
Interim applications for bail. And you have filed application for bail.
Yes, my lord. 2282.
2282.
Yes, ma'am.
Interim applications for bail shall be considered after receipt of the trial court record. Deposition copy to be supplied to the
Already
client.
supplied.
Already
With my brief.
brief.
Annexer 2.
देखिला
Copy of deposition, Annexer 2. Index page number 15.
15.
152.
Yes, madam. All right. Deposition copy ta काटी दे. Yes.
Item number 24.
May I please, Your Lordship, on behalf of Mr. Bahadur, may I express this? My Lord,
This is a appeal against conviction, my lord. The operative portion of the judgment is at page 43, my lord.
What is the sentence imposed?
Sentence imposed, my lord, 10 years, my lord.
304 part 1, 10 years. Have you supplied the deposition copy?
No, my lord. This has not been admitted, my lord.
You have received the um, copy of the appeal memo?
Yes, ma'am.
The learned counsel for the state submit that he has received the copy of the appeal memo along with the impugned judgment. Therefore, defect number 5B as per SR has already been removed. Hard admit call for the trial court record and counsel for the appearance shall supply the deposition copies to the learned counsel for the state. Interim applications for bail and stay realization of fine to be considered after receipt of the trial court record. Yes.
Right, ma'am.
Item number 26.
Mr. Sahu.
May I please? My lord, in the meantime, the
uncle has met with an accident and got his leg fractured. Your Lordship, an IA 1161 of 2023 for interim bail was filed.
What is the sentence imposed?
10 years, Your Lordship.
20B2C.
Yes, NDPC.
NDPS Act. So, how many years you are in custody?
Your Lordship, undergone more than 6 years.
Have you brought the custody certificate?
No, my lord. I will
No.
Get it, the Learning Council for the
custody certificate.
Achi?
My lord.
Surrender annexure to.
Yes, sir. Custody अच्छी है but
Sorry.
2022
ତାପରେ ଆଉ ତ ବେଲ୍ ଏଠୁ ହେଇନି ଆଉ ବେଲ୍ ଏଠି ହେଇଥିଲା କି ବେଲ୍ ନାହିଁ ତ
Your Lordship, once bail was granted, interim bail was granted once.
ଆଚ୍ଛା 14/11/22 ରେ ତାକୁ
Yes.
ବେଲ୍ ଦିଆଯାଇଥିଲା for a
4
period of 4 months, right? So
Yes, sir.
then he filed another bail application, ସେଟାକୁ consider କରାହେଇନି ଏପର୍ଯ୍ୟନ୍ତ, but so after availing that bail period, did you surrender at right time?
Yes, Your Lordship. We have annexed it. Annexure 2.
Surrender certificate.
Yes, Your Lordship. Page 9 of IA.
କେତେ ହଉଛି ହିସାବ କରୁଛନ୍ତି? ସେଟା କେବେକାର କଣ 22 ର ପରା କହୁଛନ୍ତି? କେତେ କୁହନ୍ତୁ?
6 years, 7 years.
କେବେକାର ଆଗେ ଡେଟ୍ ଟା କୁହନ୍ତୁ?
17/9/2022.
17/9/2022 କୁ କେତେ ଦିନ ହଉଛି ସେତେବେଳକୁ?
ସେତେବେଳକୁ 6 years.
6 years
and 10 days.
10 days. 17/9/2022 ହେଲେ ତାପରେ ଆଉ 1 year ଆଉ 2 months ଗଲାଣି, ତା ଦେହରୁ 6 ମାସ ସିଏ ବେଲ୍ ରେ ଥିଲେ, ତେଣୁ ସେଟା ମାଇନସ୍ କରିଦେଲେ ଆଉ 8 ମାସ ହେଇଯାଉଛି। ତ 8 months ଟା ଯଦି ଆ ଦେହରେ ଆଡ୍ କରାଯିବ ତାହେଲେ 6 ବର୍ଷ 8 ମାସ ହଉଛି। Sentence imposed is
10 years.
10 years.
All right. Heard the Learning Council for the petition. What is your name?
Your Lordship, Chinmay Vera.
Neglecting you. That out of 10 years of substantive sentence imposed by the Learning Trial Court, the petitioner has already undergone 6 years and 8 months. And there is no chance of early hearing of the appeal. And the petitioner was earlier released on interim bail for a period of 6 months, and after availing the same, he surrendered at right time. There is no chance of early hearing of the appeal. Therefore, the bail application may be favorably considered. Learned Counsel for the state has produced the custody certificate. However, he opposed the prayer for bail on the ground of seizure of commercial quantity of ganja from the possession of the petitioner at bar under section 37 of the NDPS Act. Considering the submission made by the Learned Counsel for the respective parties, sentence imposed by the Learned Trial Court, period already undergone by the petitioner in judicial custody, in absence of any chance of early hearing and keeping in view the ratio laid down by the Honorable Supreme Court in Muhammad Muslim case, bail is allowed, stay realization of fine. The advocate on लिखिए. Yes.
Item 30.
Interim bail, my lord.
कौन है जी?
Interim bail, my lord. But sister's illness, that wife's illness, my lord.
केते जण अपेलेंट आधिरे?
One, my lord.
अच्छा केते जण एडवोकेट को एंगेज करियो बोली प्रिजनर्स पिटिशन देलानी? प्रथमे कौन लिखिला एन महापात्र तापरे पुणी कौन प्रथम ज्योतिर्मय साहू थिले तापरे एन महापात्र लिखिले तापरे पुणी लिखिले राजीव बिहारी मिश्र तो लाटेस्ट कोटा
Just, my lord, Rajiv here, Mr.
राजीव बिहारी मिश्र since as per the prisoner's petition you have filed your wakalatnama. Mr. R.B. Mishra, Land Council, has filed his wakalatnama. The name of Mr. Mishra and his associates shall only be reflected in the cause list. The names of other counsel shall not be reflected. Yes, what is this bail?
Surrender and file surrender certificate, my lord.
Jaithile kete mas bail?
3 months.
Land Council for the petitioner, appellant, file the surrender certificate. Surrender certificate which is taken on record. केबे surrender कले?
25/9/2023.
अब पुणी सांगे सांगे गोटे फाइल कर देला ये ठीक है माने
Wife serious.
धैर्य टिके नहीं सांगे सांगे गले सरेंडर कले पुणी आ गोटे बेल आपली एटा कोन पे फाइल करचंदी ए जो 2491 ग्राउंड रे
Wife
आनी चंदी इंस्ट्रक्शन आनी चंदी वाइफ सेटलमेंट कोन कहउचंदी काई कोन किछि मेडिकल डॉक्यूमेंट तो किछि नहीं
previous date instruction थी.
प्रीवियस बेल तो डिस्पोज ऑफ हेगरानी बेल दियाला आ पुणी कोन
Previous date और previous date instruction थी.
मैं आपण मेडिकल डॉक्यूमेंट किछि एनेक्स करचंदी कि ए जो इंटरिम बेल की फाइल करचंदी आपण
आगे
देइचंदी अच्छा देइचंदी कोन कहउचंदी इंस्ट्रक्शन नहीं चंदी नियम तो
ऑर्डर हिता से देबे बोली बट हमु कॉपी
आउट दे दियंदो लेखन आईएन नंबर 2491 ऑफ 2023 आगुरु कोन ऑर्डर हितला देखिले
आगु हिता सूचना बे
हां आपण लेखा हितला जे इंटरिम एप्लीकेशन देले बोली कोर्ट रे तापरे मेडिकल डॉक्यूमेंट दवा कथा किछि लेखा हैनी and you are asked to obtain instruction acha likhi diyon the land and council for the state submitted that though he has received the copy of the interim application but no medical document has been supplied to him let the land and council for the appellant supply the copies of the medical documents in support of the averments taken in the interim application regarding ailment of the mother wife of the appellant put of this matter आपण काली भीतर दे दियो 4th of December 2023 yes
Item 32
Mr. Pavitra Kumar Paik नहीं के ना पासवर्ड
Item 33
पासवर्ड एटा कोन पे आछि जे
Surrender certificate.
सरेंडर सर्टिफिकेट तो अच्छी फ्लैग जी आउ तो किसी नहीं आधे एटा कन्विक्शन मैटर कन्विक्शन आउ किसी इंटरिम एप्लीकेशन नहीं ना तेणु पेर यू दी सरेंडर सर्टिफिकेट फाइल्ड बाय दी लैंड काउंसिल फॉर दी appellant at no further order is necessary the matter be listed if any further application is filed by the land council for the appellant yes
Item number 34
Mr. Subodh Kumar Mahanti कौन fresh matter हाँ
OPID
Mr. You have received the copy of the appeal memo
Right.
So what is the delay? He has stated that condone the delay conclusion. 34 दिन नहीं 84 दिन.
Date of judgment, my lord.
नहीं 84 दिन delay is conviction case pra.
No, not conviction case, my lord.
How?
A confiscation case, my lord.
अच्छा.
Confiscation of the vehicle.
Oh, that order he has challenged.
My lord.
Okay, for release of the vehicle, acha safari, so and so bearing registration number. So a passover in Mr. Patro se kalasi.
My lord.
Yes, next.
Item number 35.
Surrender certificate not received. Compliance report from flag H kon dekhi. Respectfully, with reference to I am to report that as per the dance, the accused Sanjay was released on interim bail, starting from Swanso, but on 6/8/23, accused did not surrender, violated the Swanso. All right. Non-appeals for the appellant. Surrender certificate has not been filed. Period the report of the land and session judge cum special judge Malkangiri dated 12/9/2023, from which it appears that after availing the interim bail period, the appellant has not surrendered, for which non-bailable warrant of arrest has been issued against him. The land and trial court shall intimate this court immediately on the apprehension, on the arrest of the appellant. The matter shall be placed after receipt of the notice, after receipt of the report. A copy of the order be communicated to the land and trial court. Yes.
Item number 36.
My lord, address verification and ask. Like the last chance, my lord, noting nahi order hai. To last chance कहते
देखिए, as for order dated Swanso, Land Council for the state has received instruction that documents of the local surety are genuine and he is interested to stand as a surety for appellant number 1, Nandaram alias Karan. Submit that intimation has been sent to Swanso, state of Bihar, for address verification. Achha. So आपण गोटे कोन सिक्युरिटी देले आउ गडा कोन
ଅଛି sir 18/9/23 ରେ ସେଟା क्लियर ହେଇଛି sir ଜଣେ ହଉଛି ଲୋକନାଥ ପ୍ରଧାନ ସେଟା क्लियर ହେଇଗଲା
रोंदु गोटे ना ये नाटा आसिला बलराम साहू
ସେଟା क्लियर ହେଇଗला
ठीक है रोंदु आरो नाटा कोन
ଲୋକନାଥ ପ୍ରଧାନ 18/9/23 ରେ ଅର୍ଡରଟା ହେଇଛି
18/9/23 ठीक है रोंदु कहीं लिखा है तो 18 so far as the local surety Balaram Sahu is concerned, instruction is still awaited लिखा है
ତାପରେ sir ସେ ଅଛି sir ତାପରେ ଅଛି
ये लोकनाथ प्रधान और बलराम साहू दी जन ना देइतले
हाँ
we have verified the CUT
हाँ
so far the Balaram Sahu is concerned, my lord. He is not residing in the address given, my lord. And also the Aadhaar card also could not verify because the person
no
not...
you made a submission on 30/10/2023 that Mr. Tripathi was there on that day. He said that the documents of the local surety Balaram Sahu are genuine and he is interested
document that is genuine, but report, and that report it has mentioned that he is not living there in the given address last 10 years.
माने लोकल सिक्युरिटी नुहे से
लोकल सिटी ता घर सिटी का सब सिटी रो बट से ता घरे 10 वर्ष रहउनी नाही सिटी टोटल से एरिया रे
अच्छा
डॉक्यूमेंट हैज बीन प्रोड्यूस
आउ बाकी जो
पर्सन इज कंसर्न
आरो सिक्युरिटी की
ଲୋକନାଥ ପ୍ରଧାନ
लोकनाथ प्रधान न कोन हला आपन
18-23 ରେ ସାର୍ ସେ କହି ଦେଇଥିଲେ ଯେ ଠିକ ଅଛି।
ଲୋକନାଥ ପ୍ରଧାନ ଠିକ ଅଛି ଆଜ୍ଞା ଇଏ ଗଲା ଗୋଟେ କଥା ବାକି ତାପରେ ହେଲା ସୋଫାର ବିହାର ଯୋଉଟା ହେଲା ସେଟା ବି ଏପର୍ଯ୍ୟନ୍ତ ଆମେ ପାଇନୁ let me another chance to follow the matter
ଲାଷ୍ଟ ଚାନ୍ସ ଦିଥର ଦିଆ ହେଲାଣି ସାର୍।
ବିହାର ଆସୁନି ଆଜ୍ଞା ଲାଷ୍ଟ ଚାନ୍ସ କଣ କରିବ
ସେ ଥରେ ଯାଇଥିଲେ।
ହଉ ଆଉ ଗୋଟେ ଚାନ୍ସ ଦିଆ ହଉଛି ଲେଖନ୍ତୁ the Land and Council for the state submitted that two local sureties who are found to be genuine and their documents are found to be okay are Balaram Sahu and Loknath Pradhan na
ଆଜ୍ଞା
Loknath Pradhan. However, he seeks some time for the address verification of the appellant number 1 Nandaram alias Karan. A bail application ta kebal tari pai dejan na?
ଆଜ୍ଞା
Okay, Nandaram and as the intimation has already been given to Superintendent of Police Samastipur in the state of Bihar for such verification and response is awaited. List this matter in the week commencing from 4th December 2023.
Super matter that they also mentioned let them solve another because Balaram Sahu is not
এটা লিখি দিন Balaram Sahu but he submitted that Balaram Sahu was not staying in that locality for last 10 years. The Land and Council for the state appellant may give another local surety document to the Land and Council for the state for verification in the meantime. Yes, next.
Item number 37.
Babita Sahu, Sushant Kumar Tripathi. नहीं कि ना पास हुआ अच्छा ये कौन है सरेंडर करनी पड़ा नॉन सरेंडर एट फ्लैग एफ व्यवहार करूं नॉन सरेंडर फ्लैग एफ लिखा है फ्लैग एफ कौन एटा उडा आछी एटा हां सबमिट दैट convict Dhanurjay Galari right was released on interim bail for a period of 3 months and did not surrender for which non-bailable warrant of arrest was issued acha lekhandu this is item number 37 non-appears for the appellant no surrender certificate has been filed report of the Lenin additional session judge cum special judge Malkangiri dated 27/9/2023 indicates that after availing the interim bail period, the appellant didn't surrender for which non-bailable warrant of arrest has been issued against him. So also the notice to the bailers. The Lenin trial court shall immediately intimate this court as and when the appellant is taken into judicial custody. Matter be placed after receipt of such intimation from the Lenin trial court. A copy of the order be communicated to the Lenin trial court for compliance. Yes.
Item number 38.
Mr. Ponda, Jugal Kishore Ponda, report regarding non-surrender. Lag D. ना सरेंडर करनी सेम ऑर्डर कर देबे एटी होची रिपोर्ट डेटेड होची 20/10/2023 सेशन जज गजपति पारालाखेमुंडी बाकी सब समान आफ्टर अवेलिंग दिस वन सो होला अच्छा लिखी देबे However, it is not mentioned in the report regarding steps taken by the learned session judge Gajpati. The learned session judge shall take immediate coercive steps for the arrest of the appellant and report this court for regarding complaints. है ना?
Item number 39.
May I please? The petitioner avail the 3 months bail.
Okay, 20B2C. कितने दिन रहलेनी?
In the meantime, the appellant number 1 is
एटा
in
कहाँ
fact
ପାଇଁ bail file करछन?
both Milord. During pendency of the appeal, though so far the appellant number 2 he was avail interim bail
ठीक है
6
कौन? जोरा कौन रा भूल ही छी अदर कौन लिखा ही छी? से 7 3 टा को instead of 37 एटा आप दियंतु नाली पेन दियंतु. Order number 19 question. C7 হবো। আজি তারিখ হলো না 23 না 23/11/2023 লিখিদেবে এটা। হ্যাঁ হ্যাঁ କୁହନ୍ତୁ କୁହନ୍ତୁ।
The total periods of underground 5 years, 1 month, 25 days.
wait এটা কোনটা? So state to obtain the custody certificate. Yes, Mr. আসলে আসেনি। Let you next week. Next week ରଖିବା? Right. Land Council for the state seeks some further time to produce the custody certificate of appellant number 1. ହେଲା? এটা appellant number 1 ପାଇଁ file କରିଛନ୍ତି?
So for appellant number 2. Appellant 2, he was avail interim bail, my lord.
No, ବର୍ତ୍ତମାନ IA number 630.
Both the appellant, my lord. Appellant number 1 and 2, both.
এটা କେବେକାର 632 of 20? What is your interim application number? Sorry, I have received. Just a minute. What is the interim bill ତ ଗଲା, extension ଗଲା, କଣ ବି pending କଣ
It was filed at the time of filing of the appeal, my lord.
For 632 tamane?
Yes, lord.
632 it is for, yes, both the appellants. That has, no order has been passed on that application.
No, my lord. It is
because
live.
subsequent applications have been dealt with. So 632. Six 32 ଲେଖା ହେଇଛି, this is an application for bail of appellant number 1 ଲେଖା ହେଇଛି. Appellant number 1 only. Custody certificate already received. କିନ୍ତୁ ଏଟାରେ ଦି ଜଣଙ୍କ ନାଁ ଲେଖା ହେଇଛି, ମାନେ it is not for one appellant only.
Appellants, lord. The prayer procedure release the appellants.
But in that order it is mentioned that appellant number 1, when it was taken up on 7/3, you are not pressing the application for appellant number 2.
Because, my lord, during some period he has taken consent. But subsequently he has filed prisoner petition.
Oh, okay. We have sought for instruction on appellant number 1.
Yes.
So what is the sentence, Mr. Total period is 4 years and 9 months, madam. କେବେକାର ସେଟା? ଏଟା ହଉଛି report dated 10/7. 10/7 ହେଲେ ତ ଆଉ 4 ମାସ ହେଇଗଲାଣି ନା? ଆଜ୍ଞା। ତ କେତେ ହେଲା? 10/7 ହେଲେ 4 13 5 ବର୍ଷ ଉପରେ ହେଇଗଲା। 5 ବର୍ଷ ହେଇଗଲା? ଆଜ୍ଞା। ଲୋକ କୋଉଠିକାର?
Belongs to Jaspur.
ଯାଜପୁର। 10 year sentence ହେଇଛି?
Yes, lord.
10 years, madam. Heard the Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the state, after going through the custody certificate of appellant number 1, S.K.SAHOO submits that he has already undergone half of the substantive sentence imposed by the Learned Trial Court. However, he opposed to the prayer for bail of the petitioner on merit on the ground that commercial quantity of ganja has been seized, and in view of the bar under section 37 of the NDPS Act. Learned counsel for the state submitted that the appeal is not ready for hearing, and the petitioner, appellant number 1, is a local person, and therefore there is no chance of absconding. Considering the submission made by the learned counsel for the respective parties, in view of the commercial quantity of ganja seized, bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail, but taking into account the period of sentence period already undergone by the appellant, number 1, in judicial custody and absence of any chance, I'm inclined to release him on interim bail for 3 months. IA is disposed of. Fix a date so that you will file the surrender certificate. 3 months. This is for appellant number 1. 3 months. Yes.
Item number 42.
At 42, I am in the BC. The PT appellant is in the custody for the 8 year and 8 months out of 10 years conviction. So earlier was in bail and the surrender certificate is there.
What is the surrender certificate? At flag C, acha.
I filed the custody certificate. Surrender certificate.
Surrender certificate mu custody certificate कथा कोई. Total केते period ता जरूर जाना पड़ियो. जेल सुपरिटेंडेंट को मागिले से हिसाब कर दे दी था. अच्छी की custody certificate Mr. Das. No matter. देखो ଆପଣଙ୍କ ହିସାବରେ କେତେ ଦିନ ରହିଲାଣି?
8 years 6 months 5 days.
लेकिन 8 years 6 months ରହିଛି.
Interim bail also.
କଷ୍ଟଡି ରେ ମୁଁ କେତେ ଦିନ ରହୁଛି ମାନେ କାଟିକିନି କହିବେ?
Above than 8 years.
More than 8 years.
Yes.
The more than 8 years in custody. He has to obtain the custody certificate. Please this matter give a date. 4th of December 2020. who jail कही दियंतु. Yes.
Item number 44.
Madam, IA 1482 for 2023, a female minor, 5 operation minor.
ଯାଇଥିଲା instruction ପାଇଁ ଥିଲା କଣ ଆସିଲା ଲୋକ କୋଉଠିକାର
ବିହାର
ଆଡ୍ରେସ ଭେରିଫିକେସନ ହେଇଛି ଆଗରୁ ଯାଇଥିଲେ
ବେଲେ ଯାଇ ନଥିଲେ ଅର୍ଡର ଡେଟେଡ 24/7/2023 ରେ ଇନଷ୍ଟ୍ରକ୍ସନ ଥିଲା 24/7
ମୁଁ ଆପଣଙ୍କୁ ପଚାରୁଛି ଆଗରୁ କେବେ ଇଣ୍ଟ୍ରିମ୍ ବେଲେ ଯାଇଥିଲେ ଆଡ୍ରେସ ଭେରିଫିକେସନ କରିଛନ୍ତି କି
ଆସିନି ଆଜ୍ଞା
ସୋ ଆଡ୍ରେସ ଭେରିଫିକେସନ କରନ୍ତୁ ଆଉ ସେ ଯୋଉ ତାର କାହାର ଏଲିମେଣ୍ଟ କହୁଛନ୍ତି ୱାଇଫ ର ହଁ ସେ ଏଲିମେଣ୍ଟ ନିଅନ୍ତୁ ଏଇଟା ଅର୍ଡର ପାସ୍ ହେଇଥିଲା କିଛି ସେ ବିଷୟରେ ନାଇଁ
ହେଇଛି
କେବେ ଏଇ କଣ ଅର୍ଡର ହେଇଛି ଦେଖିଲ ଆଇଏ ନମ୍ବର 1482 of 23 ଉପରେ
18/10 ହେଇଥିଲା
18/10 ହଁ ସେଇ ଅର୍ଡର ଗୁଡା କୁଆଡେ ଗଲା ହଁ 18/10/2023 କଥା କହୁଛନ୍ତି 22 ନୁହେଁ ଅପଡେଟ ଯେତିକି ଅର୍ଡର ହଉଛି ତାକୁ କରିବ ସ୍କାନ ତାକୁ ଲଗେଇବ ଆଦେହରେ यू आर ऑर्डर नंबर 12 पर्यंत अच्छी बर्तमान से ऑर्डर केते नंबर पर्यंत ऑर्डर लगा 14 नंबर 151 नंबर फाइल धरछिंदी सीआरएल हाँ instruction has been already sought for लिखचंदी
ଆଜ୍ଞା instruction sort କରନାରେ
वाइफ सेलमेंट आउ ये होची अपलेंट नंबर 2 रो से कहउजंदी श्यामदेव कुमार रो अच्छा ये लोक आगुरु केबे बेल ले जाइनी तेणु
ସେ actually କଣ ଅଛି ତା ଯୋଉ wife ରହୁଛି କି ବିହାରରେ ତା ଏଲିମେଣ୍ଟ ବୁଝିବାକୁ ପଡିବ ବିହାରରେ the deputy commissioner Berhampur has already sent a report letter to the medical officer PS Parvata district Khagaria Bihar on 3/11/2023 but no report has been received
आगुरु कोन 1 मंथ पई बेल ले जाइतला अपलेंट नंबर 1
ଆଜ୍ଞା
हां हां से सरेंडर कलानी
ମୁଁ ସେଥିରେ ନାହିଁ ମୁଁ ଆପଲାନ୍ 2 କୁ ନାହିଁ
ସବୁ ତ ସେଇ ପଟ ଲୋକ ଆଉ କୁଆଡେ ଗଲା ସେ ଲୋକ अच्छा लिखुन the London Council IA number 1482 of 2023 this is an application for interim bail of appellant number 2 Shyamdev Kumar Land Council for the state seeks some further time to obtain instruction in the matter. It appears that appellant number 1 was directed to be released on bail, interim bail for a period of 1 month. As per order dated 17/4/2023 in IA number 1663 of 2022. And there was a direction to file the surrender certificate of appellant number 1. No surrender certificate has been filed, nor any intimation has been received from the Learned Trial Court. Let a report be called for from the Learned Trial Court, that is First Additional Session Judge cum Special Judge Berhampur, in 2ACC case number 25 of 2018 bracket N, as to whether the appellant number 1 Ram Kripal Yadav upheld the interim bail order dated 17/4/2023 or not, and if so, whether he has surrendered at right time or not, and if not, what steps have been taken by the Learned Trial Court for his arrest, so also against the bailers. Report be furnished to this court by such and such date. Order be communicated to the Learned Trial Court through email by the Learned Register Judicial. List this matter on such and such date. Yes. Mention. Aji to ki korchi. Kuta. Record.
123.
May I please your lordship?